the session. And we are going to start with item 5, which is consideration of applications for observers and affiliate status from 9 o'clock to, 9:11 to about 9:30. Relationship and cooperation with national human rights institutions and non-governmental organizations. So we'll start with relationship and cooperation between the ACHPR and national human rights institutions. Consideration of applications for affiliate status for national human rights institutions. Then we go to relationship and cooperation between the Commission and NGOs, which will be consideration of applications for observer status and national human and NGOs. There will be health break from 10:30 to 11. And then we'll continue item 3, which is a human rights situation in Africa from 11 to 12. And then item 4 will be human rights situation again from 11 to 12. And then item 4, panels and launches from 12 to 12:30, which would be a panel of the death penalty. And that will be the end of P3. Thank you very much.
Madame la secrétaire exécutive, nous allons commencer avec le point 5, examen des demandes de statut d'observateur pour les ONG et de statut d'affilié pour les institutions nationales des droits de l'homme. Mais avant d'examiner, d'aller au fond de cette question, nous avons souvent l'habitude de présenter un rapport général sur nos relations, les relations et l'état de notre coopération avec les INDH. Ensuite, l'état de nos relations et de notre coopération avec les organisations non gouvernementales. Pour le premier rapport, relations et coopération avec les INDH, permettez-moi de donner la parole à l'honorable commissaire Zakaria Madford de Mwandenga pour la présentation de ce rapport. Commissioner Mwandenga, you have the floor for the presentation of the first report, please. Thank you. Je demande au secrétariat d'assister le commissaire Mwandenga pour qu'il puisse identifier le premier rapport.
Chair, is it for the application?
No, the report, the general report of our relationship with national human rights institutions. Merci Mohamed d'assister pour qu'il retrouve le rapport. Thank you very much. You have the floor.
Good morning, Chair. Good morning, Vice Chair, Commissioners. Good morning, Secretariat. Good morning, interpreters. Good morning. I have the distinguished honor of presenting this item, which is the relationship and cooperation between the African Commission and national human rights institutions and specialized human rights institutions. I begin, Chair. The African Commission on Human and People's Rights recognizes the particular role that national human rights institutions play in the promotion and protection of human rights in Africa. As mandated by Article 45(1) of the African Commission on Human and People's Rights, the Commission has formalized its relationship with national human rights institutions through the grant of affiliate status. Resolution 370 on the granting of affiliate status to national human rights institutions and specialized human rights institutions in Africa provides that the benefits of the grant of affiliate status include being invited to sessions of the Commission and participating without voting in deliberations on issues which are of interest to them. Resolution 370 also provides that NHRIs and specialized human rights institutions with affiliate status have the following responsibilities: assisting the Commission in the promotion and protection of human rights at the national level, and presenting their activity reports to the Commission every 2 years. Status of submission of activity reports to the Commission as at the 77th ordinary session held in November 2023, 36 national human rights institutions have been granted affiliate status with the Commission. 34 national human rights institutions, national human rights institutions, and 2 specialized institutions. During the intersession period prior to the commencement of the 79th ordinary session, the Commission received 1 activity report from the Cameroon National Commission for Human Rights and Liberties, which is affiliate number 20. The following provides the status of submission of activity reports by NHRIs and specialized institutions in the Commission. The reports have been tabulated as follows. No reports owed. Reports submitted during 2022 to 2024. The Ethiopian Human Rights Commission submitted before the 75th ordinary session in May 2023. The National Commission for Rights and Citizenship of Cape Verde report submitted before the 75th ordinary session in May 2023. The National Commission for Human Rights, the Sudan, report submitted before the 73rd ordinary session in October 2022. For Commission for Human Rights and Good Governance of Tanzania, report submitted before the 77th ordinary session in October 2023. Last but not least, under this category, Cameroon National Commission for Human Rights and Liberties, report submitted before the 79th ordinary session in May 2024. The next group is those granted affiliate status during 2022 to 2024. 1, the National Commission for Human Rights of the Arab Republic of Egypt was granted status in the 73rd ordinary session in November 2022. The second one is the Independent National Commission on Human Rights of Liberia, was granted affiliate status in the 73rd ordinary session in November 2022. And the third one is the Independent National Human Rights Commission of Madagascar, which was granted affiliate status in the 73rd ordinary session in November 2022. Here, I would tabulate the list of NHRIs owing 1 or more reports. South Sudan Human Rights Commission, Sahrawi National Commission for Human Rights, National Human Rights Commission of the Democratic Republic of Congo, the National Human Rights Commission of Nigeria, National Human Rights Commission of Mali, National Human Rights Commission of Niger, South African Human Rights Commission, Uganda Human Rights Commission, Human Rights Commission of Sierra Leone, National Human Rights Commission of Togo, National Human Rights Commission of Chad, National Human Rights Commission of Burkina Faso, Senegalese Human Rights Committee, the National Human Rights Commission of Mauritania, Zambia Human Rights Commission, Mauritius National Human Rights Commission, Independent National Commission on Human Rights of Burundi, Zimbabwe Human Rights Commission, the Gender Commission for the Commission for Gender Equality, South Africa, National Council for Human Rights of Ivory Coast, Ghana Commission on Human Rights and Administrative Justice, Benin Human Rights Commission, the National Human Rights Commission of the Gambia, the Institute of Human Rights and Peace of Sheikh Anta Diop University, National Commission for Human Rights of Rwanda, Kenya National Commission on Human Rights, Malawi Human Rights Commission, National Council for Human Rights of Algeria. There are 28 in number. In conclusion, Chair and Commissioners and distinguished delegates, the Commission would like to encourage NHRIs with affiliate status with overdue activity reports to submit them to the Commission in accordance with the requirements of Resolution 370. Chair, Commissioners, Secretariat, and delegates ends the reports which I was tasked to present. Thank you.
Thank you, Commissioner Mwandenga. Mesdames et Messieurs les commissaires, vous avez suivi l'état de nos relations et de notre coopération avec les INDH. Je vais ouvrir le débat général sur cette question pour vos commentaires et observations éventuelles si vous en avez. Je ne vois pas de demande de parole dans la salle. Etienne, online, we have some commissioners who want to take the floor. Nobody wants to take the floor. Nous pouvons donc considérer que ce rapport présenté par le commissaire Mwandenga est adopté. La commission a pris bonne note de ce rapport. Comme nous l'avons toujours dit, notre institution c'est ceci un organe de coopération et de diplomatie. Le statut d'affilié, ça restera toujours un important outil mis à notre disposition pour améliorer, en tout cas pour créer, jeter des ponts avec les institutions internationales, les organisations internationales, les organisations intergouvernementales, ainsi que les institutions spécialisées dans le cadre de ce mandat de coopération qui nous est reconnu. Le défi, comme l'a souligné le commissaire Mwandenga, avoir le statut d'affilié, c'est bon, mais il faudrait aussi que ces institutions n'oublient pas un certain nombre de leurs obligations, dont celui de rendre compte, de nous fournir des rapports sur les états d'activité et de coopération que nous avons avec eux. Ceci dit, je voudrais encore demander au commissaire Mwandenga, suivant la décision que nous avions prise hier, de nous présenter le rapport maintenant en ce qui concerne les organisations non gouvernementales. Commissioner Mwandenga, you have again the floor for the second report.
Thank you, Chair, Vice Chair, Commissioners, Secretariats, as well as distinguished delegates and the interpreters. It is now my distinct honor to present a report on the relationship and cooperation between the African Commission on Human and People's Rights and NGOs. Article 45(1)(c) of the African Charter on Human and People's Rights mandates the African Commission on Human and People's Rights, the Commission, to cooperate with the African and international institutions concerned with the promotion and protection of human and people's rights. As at the 77th ordinary session held in November 2023, the Commission had enhanced its criteria for granting observer status by adopting Resolution 572 on the criteria for granting and maintaining observer status to non-governmental organizations working on human and people's rights. Resolution 572 on the criteria for granting and maintaining observer status to non-governmental organizations working on human and people's rights in Africa recognizes the important role of NGOs in supporting the Commission to fulfill its mandate of promoting and protecting human and people's rights in Africa. Furthermore, the resolution states that NGOs with observer status shall undertake to establish close relations of cooperation with the Commission and to engage in regular consultation with it on matters of common interest and present their activity reports to the Commission every 2 years. Status of granting observer status to non-governmental organization follows as I shall proceed. As at the 77th ordinary session held in November 2023, the Commission granted observer status to 9 NGOs in accordance with the resolution on the criteria for granting and maintaining observer status to non-governmental organizations working on human and people's rights in Africa, namely Afya na Haki Institute, CEDH, Consortium of Ethiopian Human Rights Organizations, the African Center for Justice and Peace Studies, the National Coalition of Human Rights Defenders, Uganda, Forum for African Women Educationalists, Forum for Development and Human Rights Dialogue. Well, I can't pronounce this one, it's in French. Then the last one is Wellbeing Africa. The Commission also considered and rejected applications for observer status of 5 NGOs, namely ADF International, International Network for Economic, Social and Cultural Rights, the GAIA Foundation and Transatlantic Christian Council, due to the absence of a registered office in one of the states parties to the African Charter on Human and People's Rights, the African Charter. Additionally, the application for All Africa Conference of Churches, due to its status as a diplomatic entity not aligning with the criteria set forth by the Commission. The Commission also struck out and closed 96 pending applications for which no response had been received regarding the request for additional information to complete the applications for consideration for observer status. Status of submission of activity reports to the Commission. As at the 77th ordinary session held in November 2023, 561 NGOs have been granted observer status with the Commission. During the intersession period prior to the commencement of the 79th ordinary session, the following 9 NGOs submitted their activity reports to the Secretariat of the Commission. Dula Omar Institute, FIACAT, International Lawyers .org, International Service for Human Rights, Movement for the Abolition of Torture, Prison Fellowship Nigeria, the Global Initiative for Economic, Social, and Cultural Rights, Under the Same Sun, Tanzania, and World Coalition Against the Death Penalty. To date, among the 561 NGOs with observer status, 407 NGOs have submitted one or more reports on their activities. The Commission would like to commend these NGOs for fulfilling the requirement of submitting activity reports and takes this opportunity to call on all NGOs which enjoy the benefits of observer status to consistently submit activity reports to the Commission every 2 years in line with the provisions of Resolution 572. Here in the Commissioners, Secretariats, interpreters, and distinguished delegates, this is the end of the report on the relationship and cooperation between African Commission and the NGOs. Thank you, Chair.
Merci, commissaire Watford Mandenga. Je vais demander aux commissaires s'ils ont des commentaires à faire sur ce rapport important des ONG. Relations avec les ONG, relations et coopération avec les ONG. Est-ce que vous avez un commentaire? Non? Et toi? Non. Ok, merci beaucoup. On peut considérer également ce rapport comme étant adopté. Je tiens particulièrement à féliciter les 9 ONG sur les 561 qui ont le statut d'observateur à la Commission, près la Commission, d'avoir soumis le rapport, notamment la FIACAT et les autres, International Service for Human Rights et les autres, 7 organisations que je ne vais pas citer parce que le commissaire Mandenga les a tous cités. Merci beaucoup. On va donc passer maintenant à l'examen des demandes de statut d'observateur présentées par les ONG. Les demandes de statut d'observateur présentées par les ONG. La liste, vous les avez, commissaire, dans vos fardes respectives, dans vos chemises respectives. Nous allons commencer par le mécanisme national de prévention de la torture, Mauritanie. En Mauritanie, je pense. C'est une ONG de la Mauritanie qui a soumis sa demande fin 2023, en novembre, avec des objectifs de prévention de la torture et autres peines ou traitements cruels, inhumains ou dégradants en Mauritanie. Et cette demande sera analysée par la commissaire Annette Salandjaye. Il s'agit plutôt de demandes pour les INDH, d'abord les INDH et puis on fera les ONG après. Commissioner Salandjaye, can you present the first application, please?
Thank you very much, Chair. Good morning, Chair, colleague commissioners, distinguished delegates from member states, delegates, members of the Secretariat. It is my distinct honor and privilege to present the application for affiliate status filed by the National Mechanism for Prevention of Torture of Mauritania and to communicate the petition of the Commission on this application. This mechanism was established by law number 34 of 2015 of the Islamic Republic of Mauritania. Place of registration is Nouakchott, and the date of the application, as we've been informed by the chair, is the 6th of November, 2023. The National Mechanism for the Prevention of Torture of Mauritania is an independent and permanent institution established by law of the legislature of Mauritania. The mechanism is a national mechanism for the prevention of torture and other cruel, inhuman, or degrading treatment or punishment. It enjoys financial and functional autonomy, and it has a broad statutory mandate of promotion, protection, and monitoring of human rights. In accordance with our guidelines for the grant of affiliate status, we reviewed this application and confirmed that it is established by law. It's a national mechanism. It enjoys independence guaranteed by law, has a board of commissioners, and staff are under no control of any branch of government. It has a broad mandate of promotion, protection, and monitoring of human rights. The mechanism carries out regular, scheduled, or unannounced visits without prior notice at any time to all places where persons are or may be deprived of their liberty in order to obtain information on the conditions of detainees and to ensure that they have not been subjected to torture or other cruel, inhuman, or degrading treatment or punishment. The mechanism receives complaints and allegations of torture and other cruel, inhuman, and degrading treatment or punishment occurring in places of deprivation of liberty and forward them to administrative and judicial authorities or institutions competent to investigate them. The commissioners and other staff of the mechanism have unhindered access to prison and all detention facilities, including police holding cells and prisons throughout the Republic. The mechanism makes recommendations for the prevention of torture and other cruel, inhuman, or degrading treatment, taking into account relevant United Nations standards and monitor their implementation. It carries out research and publishes the research and studies that it carries out, publishes an annual report on its activities submitted to the President of the Republic. And this report is also submitted to the National Assembly of Mauritania. It is adequately funded and not subject to financial control. It is accessible to the general public. It is composed of a diverse membership representative of civil society. Documents that were required were duly submitted by the mechanism, and a thorough analysis was carried out. And the end, the commission, in view of all the analysis that were carried out, took a decision that affiliate status be granted to the National Mechanism for the Prevention of Torture of Mauritania. I submit, Chair.
Merci beaucoup, commissaire. Madame la vice-présidente Ramatoulaye Sarr. Cher commissaire, on nous a présenté la première demande d'application avec une décision provisoire d'octroi du statut d'affilié au mécanisme national de prévention de la torture en Mauritanie. Est-ce qu'il y a un commissaire qui a un commentaire qu'il souhaite faire sur cette question? Non. Et en ligne, il y a quelqu'un qui a demandé, le commissaire? Non. Nous pouvons donc considérer que cette demande est approuvée. Nous avons donc octroyé le statut d'affilié au mécanisme national de prévention de la torture en Mauritanie. Je présente à cette institution les félicitations de la Commission africaine des droits de l'homme et des peuples et de l'ensemble des commissaires. On va passer au deuxième. La deuxième requête, c'est National Gender and Equality Commission, NGEC. C'est une structure du Kenya dont le statut a été soumis à la même date que la précédente, qui venait d'être présentée le 2 novembre 2023. Commissaire Solomon Aele Derso va nous présenter cette requête. Commissioner Derso, you have the floor.
Thank you very much, Chair. Let me start, this is my first time to intervene, by wishing you all a very good morning for those of you here in Banjul and those of you following us from wherever you are. Good morning or good afternoon. I would like also to wish good morning to colleagues, not just members of the Commission, but also staff of the Secretariat and our interpreters. Good to see you all in good health. As the Chair mentioned, we have received an application for affiliate status from the National Gender and Equality Commission of Kenya. The National Gender and Equality Commission is an independent national human rights institution established by the National Gender and Equality Act, number 15 of 2011, pursuant to Article 59(4) and 5 of the Constitution of the Republic of Kenya, 2010. The Commission's mandate is to promote gender equality and freedom from discrimination for all people in Kenya, with a focus on special interest groups, which include women, children, youth, persons with disabilities, older persons of the society, minority and marginalized groups. As noted, it is established by law, Act number 15 of 2011 of Kenya. It is a human rights institution of a state party to the African Charter on Human and People's Rights. The Commission enjoys independence that is guaranteed by law. The Board of Commissioners and staff are not under the control of any branch of government. Article 59 of the Constitution of the Republic of Kenya gives a broad mandate on the protection, promotion, and monitoring of human rights through various means, and the list is provided in the summary below. And with respect to, I think, the Commission also have the power beyond and above those listed in Article 59, involving the promotion of respect for human rights and develop a culture of human rights, gender equality, and equity generally, facilitating gender mainstreaming in national development as stipulated in the Constitution. Other power include to conduct investigations on its own initiative or on a complaint made by a member of the public, powers for conciliation, mediation, and negotiation, and it has the power to recruit its own staff. The Commission shall have the powers of a court to issue summons or other orders requiring the attendance of any person before the Commission and the production of any document or record relevant to any investigation by the Commission, question any person in respect of any subject matter under investigation before the Commission, and require any person to disclose any information within such person's knowledge relevant to any investigation by the Commission. The Commission is also funded, and its funding is not subject to it says it's not subject to financial control, but it can't be that. It's not subject to financial control by the executive body. I think that's what it's meant to be. The Commission is funded through the National Treasury, using public funds for its programmatic development and recurrent needs as provided for in the Paris Principles. So it's Paris Principles compliant commission. It is accessible to the general public. It is composed of diverse membership, representative of the society. The current composition of the Board of Commissioners of the Commission comprises 5 members from diverse backgrounds, including sex, professional pursuits, geographic origin, or ethnicity. The application is accompanied with a list of required documentations, including formal letter of application dated 6 November 2023, the Constitution of the Republic of Kenya 2010, which established the basis for the establishment of the commission. Act number 15 of 2011 of Kenya, which actually established the commission. The commission's list of members, information on the source of funding as noted above, documentation showing how the applicant institution conforms to the criteria established by the African Commission on Human and People's Rights on receiving affiliate status before the commission. According to the analysis of the Secretariat, the National Gender and Equality Commission of Kenya applied for affiliate status as mentioned earlier on 6 November 2023, and it has fulfilled all the requisite requirements relating to being duly established by law, working on and as a national human rights institution, had independence, a broad mandate, capable of promoting, protecting, monitoring human rights through various means, including, as we indicated, a quasi-judicial role as well. It is adequately funded, accessible to the public, and made up of members that are representative of the broad society. In the light of the foregoing, and considering the precedent from the Commission in granting of the affiliate status to the Gender Commission of South Africa, we are of the view that this commission grants the request of the National Gender Equality Commission of Kenya affiliate status. Thank you for your attention.
Merci beaucoup, commissaire Derso, pour la présentation succincte de cette demande de statut d'observateur de cette INDH du Kenya, le National Gender and Equality Commission. Commissaire, vous avez maintenant la parole pour poser une question de clarification ou un avis d'objection ou de non-objection. Je ne vois pas de demande de parole. Actuel, Commissioner Online are requesting the floor? No. Okay, thank you very much. Je pense que honnêtement, ce dossier qui est également présenté de manière claire comme le premier mérite que nous puissions suivre l'avis qui est proposé par le commissaire Derso. Nous avons donc donné un avis favorable à National Gender and Equality Commission, NGEC. Je présente à cette institution les félicitations de la Commission africaine des droits de l'homme et des peuples et de l'ensemble des commissaires. Nous allons maintenant passer au deuxième segment de ce dossier, les demandes de statut d'observateur par les ONG. Et la première ONG, c'est Afro-Giveness du Cameroun qui a soumis ce dossier en janvier 2024. Et en tant que rapporteur pays, je vais vous présenter les dossiers. L'adresse de cette institution, c'est Mombankolo à Yaoundé au Cameroun. Et elle a été enregistrée depuis le 23 août 2021 auprès des autorités nationales et sa demande a été soumise depuis le 25 janvier 2024. C'est une organisation de la société civile qui œuvre pour la réhabilitation des survivants des conflits et de l'intolérance et la lutte contre l'extrémisme violent, en impliquant et en autonomisant les jeunes survivants traumatisés par ces conflits et l'intolérance pour contribuer à la paix et au développement au Cameroun. L'ONG fournit également des plateformes grâce auxquelles les survivants de ces conflits, les victimes de cette intolérance peuvent guérir par le pardon et la libération à travers la formation aux arts. Peinture, tableau, tout ça, céramique. Sa vision, c'est de créer un monde où les survivants armés, des conflits armés et de l'intolérance peuvent guérir par le pardon et se libérer ainsi en faisant les arts et en transformant leur traumatisme en un trésor pour pouvoir avancer dans la société. Mission, c'est permettre aux survivants de ces conflits et aux victimes de l'intolérance de guérir en recourant à l'art, en utilisant leur talent artistique pour défendre les droits humains. Les objectifs de l'ONG, c'est améliorer la santé mentale des survivants des traumatismes des guerres et de l'intolérance en les aidant à guérir grâce à la pleine conscience et à la libération que leur procure l'art, la peinture, céramique et autres. Ça vise également à renforcer psychologiquement, moralement et spirituellement ces victimes de violations des droits de l'homme pour que ces personnes puissent devenir des vainqueurs, puissent maîtriser leur propre vie en transformant la douleur qu'elles ont subie en des objectifs. Aider également à raconter les histoires inédites, souvent inconnues du grand public, des conflits du point de vue des survivants. Parmi les documents soumis, ils ont soumis une lettre de demande, une requête, une liste des membres de l'ONG, un certificat d'enregistrement, le statut dûment signé par les membres fondateurs, leur source de financement et un état financier certifié par un audit indépendant en décembre 2021. Ils ont également soumis un rapport annuel de leurs activités de 2022 et leur plan stratégique couvrant une période de 4 ans, 2023 à 2024. S'agissant d'une demande qui émane d'une organisation dont les principaux objectifs sont conformité avec la Charte africaine des droits de l'homme et du peuple au titre du droit à la santé, santé mentale ici, et considérant le fait que cette requête contient tous les éléments pertinents requis par la résolution de la Commission africaine des droits de l'homme et du peuple sur les critères d'octroi et de jouissance du statut d'observateur aux ONG qui travaillent dans le domaine des droits de l'homme, et considérant également le fait que la structure est enregistrée dans un État partie à la Charte africaine des droits de l'homme et du peuple, nous proposons, au vu de ce qui précède, au vu des pièces du dossier, que la Commission puisse décider que le statut d'observateur est accordé à forgiveness. Tel est l'état de ce dossier. J'ouvre le débat si vous avez des questions de clarification à poser ou des compléments d'information à demander. Est-ce qu'il y a des demandes de parole? Non. En ligne, Étoile? Avec votre autorisation, mesdames et messieurs les commissaires, nous pouvons considérer que Forgiveness obtient le statut d'observateur et au nom de la commission, nous lui adressons nos sincères félicitations. La deuxième organisation non gouvernementale, c'est Association IPSAR. C'est une association de Tunisie qui a soumis sa demande au milieu de l'année 2023. Le rapporteur pays de la Tunisie, l'honorable Selma Sassi, pourrait nous présenter la requête. Vous avez la parole.
Je vous remercie, Monsieur le Président, de m'avoir accordé la parole. Honorable commissaire, distingués représentants des États, des organes de l'Union africaine, représentants des INDH et des organisations de la société civile, membres du secrétariat, interprètes, honorable assistance, bonjour. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. Permettez-moi, Monsieur le Président, de présenter des résumés ainsi que les décisions de la Commission sur les demandes de statut d'observateur auprès de notre Commission déposées par 3 ONG enregistrées en Tunisie, État pour lequel je suis rapporteur pays. Il s'agit, dans un premier temps, de l'association IPSAR pour le loisir et la culture pour les non et malvoyants en Tunisie. C'est une organisation non gouvernementale qui a été enregistrée en République de la Tunisie le 23 mars 2015 et qui a présenté sa demande auprès du secrétariat de notre commission le 2 août 2023. L'association IPSAR est une association qui œuvre pour la culture et les loisirs des personnes ayant un handicap visuel et pour promouvoir les droits et l'inclusion des personnes handicapées en général en Tunisie. Les objectifs principaux de cette ONG sont de promouvoir les droits et l'inclusion des personnes handicapées afin d'élaborer et de promouvoir des recommandations visant à améliorer l'accès et la participation des personnes en situation de handicap en Tunisie. Les objectifs de cette association sont donc conformes aux objectifs de l'acte constitutif de l'Union africaine ainsi qu'aux objectifs cités dans le préambule de la Charte africaine des droits de l'homme et des peuples. L'association également œuvre dans le domaine des droits de l'homme en Afrique tel qu'exigé par la résolution 572-2023 de la Commission africaine des droits de l'homme et des peuples, résolution sur les critères d'octroi et de maintien du statut d'observateur aux organisations non gouvernementales en charge des droits de l'homme et des peuples en Afrique. À cette demande présentée par l'ONG en question, l'association IPSAR a également joint un ensemble de documents comme exigé par la résolution précitée. Après analyse du secrétariat et suite à l'examen de la commission décide d'octroyer le statut d'observateur à l'association IPSAR pour le loisir et la culture pour les non-voyants et malvoyants en Tunisie, auprès de notre commission. Il s'agissait de la première demande. Nous passons à présent à la seconde demande. Ah oui, excusez-moi, Monsieur le Président, je vous redonne la parole et je la reprends juste après.
C'est
Merci.
pour qu'on décide déjà par rapport à la première et puis on passera à la deuxième demande. Donc, mesdames et messieurs le commissaire, on nous a présenté la requête de la coalition, de l'association IPSAR avec une proposition de décision de l'octroi du statut d'observateur. Est-ce que vous avez des commentaires à faire par rapport à ça? Je ne vois pas de demande de parole. Le statut d'observateur est accordé à l'association IPSAR et nous lui présentons les félicitations au nom de la Commission africaine des droits de l'homme et des peuples et de l'ensemble des commissaires. Vous pouvez passer à l'autre.
Je vous remercie, Monsieur le Président. Nous passons à présent à une autre demande qui a été déposée cette fois-ci par la coalition tunisienne contre la peine de mort, CTCPM. Il s'agit d'une coalition qui a été enregistrée toujours en République de Tunisie le 30 juin 2012 et qui a déposé sa demande pour le statut d'observateur auprès de notre commission au niveau de notre secrétariat le 30 juillet 2023. La coalition tunisienne contre la peine de mort est une organisation non gouvernementale, indépendante, dont les objectifs sont l'abolition de la peine de mort en Tunisie via la constitution et le développement d'un mouvement citoyen. Les principaux objectifs de cette ONG sont de mener une campagne pour prévenir les risques de rétablissement de la peine de mort en Tunisie, de renforcer le plaidoyer pour maintenir le vote de la Tunisie en faveur de la résolution de l'Assemblée générale des Nations unies appelant à un moratoire universel sur l'application de la peine de mort et d'assurer un accès libre et indépendant à tous les lieux de détention pour les organisations de la société civile et les instances des droits de l'homme et des peuples. Les objectifs de cette ONG s'inscrivent ainsi, comme l'exige la résolution sur l'octroi et le maintien du statut d'observateur de notre commission, en conformité, encore une fois, avec les objectifs de l'acte constitutif de l'Union africaine et également des objectifs dans le préambule de la Charte africaine des droits de l'homme et des peuples. La liste des documents qui ont été produits par cette ONG est joint à la demande, entre autres, une liste des membres de l'ONG, la liste des ONG membres à la coalition, un certificat d'enregistrement, les statuts signés et authentifiés, les sources de financement, un état financier certifié par un audit indépendant, un rapport d'activité et un plan stratégique sont conformes également aux exigences de la résolution précitée. Au vu de ce qui précède et après analyse du secrétariat et examen de la commission, notre commission décide d'octroyer le statut d'observateur à la coalition tunisienne contre la peine de mort.
Merci pour cette requête claire bien présentée. Mesdames et messieurs les commissaires, avez-vous des commentaires sur cette deuxième requête d'une structure qui est basée en Tunisie? Je ne vois pas. Donc, nous octroyons le statut d'observateur à la coalition tunisienne et nous les félicitons au nom de tous les commissaires et de la commission pour ce statut qui vient de leur octroyer par la commission. Vous allez continuer avec le troisième dossier de Dignity, surtout, toujours en Tunisie. Merci.
Je vous remercie, Monsieur le Président. Nous passons à présent à une demande qui a été présentée par l'Institut danois contre la torture, Dignity. Cette organisation internationale a été enregistrée en Tunisie et a un bureau régional en Tunisie, donc un pays africain partie à la Charte africaine des droits de l'homme et des peuples, ainsi que l'exige la résolution 572-2023 sur les critères d'octroi et de maintien du statut d'observateur aux ONG en charge des droits de l'homme et des peuples en Afrique. L'ONG Dignity a présenté sa demande auprès de notre commission en date du 23 février 2024. L'Institut danois contre la torture est une organisation internationale de défense des droits de l'homme et de développement. Elle travaille essentiellement à la prévention de la torture et de la violence, à la réhabilitation des victimes traumatisées et apporte son soutien aux organisations partenaires locales pour documenter les violations graves des droits de l'homme, mais également pour juger les responsables de ces actes. Les objectifs principaux de cette ONG sont de renforcer les autorités publiques, essentiellement prisons, police et système de justice pénale, ainsi que les acteurs de la société civile, afin de prévenir la torture et les peines ou traitements cruels, dégradants ou inhumains. Un des autres objectifs est le renforcement des autorités nationales et locales, ainsi que les acteurs de la société civile, pour prévenir les différentes violences au sein des communautés. Enfin, le renforcement également des autorités de l'État et des acteurs de la société civile afin d'offrir une réadaptation rapide et de qualité aux survivants de la torture et d'autres formes de violence. Ces objectifs sont ainsi en adéquation avec les objectifs de l'acte constitutif de l'Union africaine et des objectifs contenus dans le préambule de la Charte africaine des droits de l'homme et des peuples. Il apparaît également clairement que cette organisation œuvre dans le domaine des droits de l'homme en Tunisie. Une liste de documents a été introduite par l'ONG Dignity et elle est également conforme aux critères qui sont établis par la résolution déjà précitée. Aussi, et après l'analyse du secrétariat et examen de la commission décide d'octroyer le statut d'observateur à l'Institut danois contre la torture Dignity auprès de la Commission africaine des droits de l'homme et des peuples. Je vous remercie, Monsieur le Président.
Merci beaucoup, commissaire Seyd Massassi. Mesdames et messieurs les commissaires, vous avez suivi la lecture de cette requête qui provient de cette ONG. Est-ce que vous avez des observations, un avis, des non-objections, eh bien, vous soutenez la décision? Je ne vois pas de demande de parole, ni ici, ni en ligne. Je pense que nous pouvons valider, prendre la décision comme quoi l'Institut danois contre la torture Dignity a désormais un statut d'observateur sur base de la décision de la Commission africaine des droits de l'homme et des peuples. Et nous leur présentons les félicitations, nos vives félicitations au nom de l'ensemble des commissaires. Je vais présenter pour une autre ONG du Cameroun, c'est le Center for Human Rights and Democracy, CHRDA. Cette association a une adresse au Cameroun, à Buea, dans le Southwest Region. Elle a été enregistrée sur le plan local depuis août 2005 et elle a soumis cette demande depuis 2020 ici à la Commission africaine des droits de l'homme et des peuples. Le Centre pour les droits de l'homme et la démocratie en Afrique, c'est une organisation non gouvernementale indépendante, apolitique et à but non lucratif qui se charge de la protection et de la promotion des droits de l'homme, ainsi que la promotion de la démocratie en tant que culture politique en Afrique. Il s'engage en tant que centre dans les questions variées et sensibles liées à la promotion des droits de l'homme et de la démocratie. Elle a pour vision de propulser, de promouvoir la culture des droits de l'homme à travers le Cameroun et à travers l'ensemble du continent africain. Sa mission, c'est de permettre aux États et aux individus, groupes d'individus, d'arriver à une culture des droits de l'homme sur toute l'étendue de l'Afrique et que la dignité de chaque personne humaine, de chaque Africain, de chaque personne qui vit sur le territoire africain puisse être respectée. Quels sont les objectifs? C'est renforcer la promotion et le respect des droits de l'homme, de l'état de droit et renforcer également la promotion des principes démocratiques en Afrique. Promouvoir la démocratie et la bonne gouvernance et développer des stratégies en mobilisant des ressources pour garantir les droits, les normes des droits de l'homme sur le continent africain de manière générale. Ils ont soumis dans le dossier, les pièces du dossier que nous avons consultées, une lettre de demande, une liste des membres de cette organisation non gouvernementale, un certificat d'enregistrement prouvant qu'ils se sont fait connaître aux autorités nationales du Cameroun. Ils ont des statuts dûment signés par les fondateurs. Ils ont des sources de financement que nous considérons comme fiables. Nous n'avons aucune raison de penser que ces sources ne sont pas crédibles. Ils ont un état financier certifié par un audit indépendant suivant les critères qui sont les nôtres. Et cet audit date de 2021. Ils ont soumis un rapport annuel couvrant l'exercice 2022 et ils ont un plan stratégique quinquennal qui couvre leurs activités pour la période de 2020 à 2025. Dans notre analyse, nous pensons que les principaux objectifs et les activités de cette institution s'alignent en tout cas, sont en parfaite conformité avec les objectifs que poursuit la Charte africaine des droits de l'homme et des peuples. Cette requête contient tous les documents pertinents exigés par la résolution sur l'octroi du statut d'observateur aux organisations non gouvernementales qui travaillent dans le domaine des droits de l'homme et des peuples. C'est une organisation connue des autorités nationales, comme je l'ai dit. Elle est enregistrée à partie à la Charte africaine des droits de l'homme et des peuples. Et puis, ce qui précède, vu l'analyse des pièces du dossier, nous vous proposons la décision de l'octroi du statut d'observateur au Centre pour les droits de l'homme. Accordé et nous leur adressons au nom de la Commission africaine des droits de l'homme et des peuples et de l'ensemble des commissaires. Sincère remerciement. Je vais maintenant passer la parole au commissaire de Ethiopian Human Rights Lawyers. C'est une structure qui a soumis ce dossier depuis 2022. Le reporter pays commissaire Ndenga pour représenter le dossier. Commissaire Ndenga, you have the floor.
Thank you, Chair. I have the honor to present an application
Viens
for
ouvrir ça là, mon enfant. Coupe ton micro, s'il te plaît, là, c'est il faut couper micro et caméra.
NGO, which is registered in the Republic of Ethiopia. It was registered on the 18th September 2019. The date of the application is 10 February 2022. Lawyers for Human Rights is an Ethiopian civil organization, promote awareness, protection, and enforcement of human rights by increasing the participation and contribution of lawyers in the area of human rights to ensure the protection of fundamental rights and freedoms guaranteed by the Constitution and other laws, including international human rights laws, presenting proper defense in courts litigation. The vision statement to be among flying human rights and ability advocates and watchdogs in Ethiopia, in the sub-region, and an effective domestic sub-regional force in the development of the human rights. Mission, promote awareness in the enforcement of human rights, education, advocacy, capacity building, research, legal services, and accountability.
Yo,
of the objectives are: 1, promote awareness, protection, and enforcement of human rights through litigation and advocacy. 2, facilitate unimpeded access to and administration of justice by making available high quality and free legal service. 3, fighting impunity for human rights violations by ensuring accountability of perpetrators. 4, strengthen the capacity of lawyers and human rights advocates through tailor-made trainings. And lastly, but not the least, 5, strengthen laws, policies, institutional frameworks through proactive consultations, monitoring, research, and advocacy. The following documents were submitted: a letter of application dated 11 February 2022, list of board of directors, registration dated 29th April 2019, signed articles of association dated October 2022, sources of funding, independent audited financial statement as at July 2023, and 2022 and 2023 annual reports. And lastly, but not the least, the strategic plan 2023 to 2026. The analysis of the Secretariat: this application is from an organization whose main objectives and activities are in consonance with the fundamental principles and objectives enunciated in the AU Constitutive Acts and the African Charter on Human and People's Rights. The application contains all the relevant documents as required under the Commission's resolution on the criteria for granting and enjoying observer status to NGOs working in the field of human and people's rights. The NGO is registered and has an office in a state party to the African Charter. The Secretariat recommends that observer status be granted to lawyers for human rights, and the decision of the Commission is that upon consideration of the application and the recommendation of the Secretariat, the Commission decides to grant the NGO Lawyers for Human Rights observer status. Thank you, Mr. Chairman.
Merci beaucoup, commissaire Mwandenga, pour la présentation de cette requête précise, concise et succincte. Mesdames et messieurs les commissaires, avez-vous des observations à faire? Personne ne souhaite faire des observations parce que les critères sont bel et bien en place. Nous décidons donc, sur base de la proposition faite par le commissaire Mwandenga, d'octroyer le statut d'observateur à Ethiopian Human Rights Lawyers. Et au nom de la commission, nous leur adressons nos sincères félicitations. La prochaine institution c'est Hope Inspired Foundation for Women and Youths with Disabilities. C'est une ONG du Nigeria. Je vais demander au rapporteur pays, le commissaire Solomon Ayel Ederso, de nous présenter ce dossier. You have the floor, Commissioner Ederso.
Thank you. Hope Inspired Foundation for Women and Youth with Disabilities is a Nigerian-based non-governmental organization, the address of which is provided in the application and in this summary. Its date of registration is 27 February 2015, and date of application to the Commission, 20 November 2023. Hope Inspired Foundation for Women and Youth with Disabilities is a women-led, non-governmental organization registered in Nigeria. The NGO aims to provide a platform for the promotion of the well-being and protection of the rights of young women, girls, and youth, particularly those with disabilities, through education, empowerment, and advocacy for independence and productive living, as well as equal participation in all aspects of community life. The vision of the NGO is a society where women and youth, regardless of disability or any circumstance, can actualize their potentials and live their dreams. Its mission is to promote rights, inclusion, and empowerment of women, girls, and youth with and without disabilities through advocacy, capacity building, livelihood support, and public engagement. The objectives of Hope Inspired Foundation for Women and Youth with Disabilities include women and girls and youth with disabilities encounter less attitudinal, institutional, and environmental barriers as a result of increased and robust public engagements on their rights and inclusion, to make effective use of comprehensive capacity strengthening programs geared towards promotion and sustenance of advocacies and appropriate policy and programmatic responses to issues that affect women, girls, and youth with disabilities. Support rights protection, social inclusion, and economic empowerment for women, girls, and youth with disabilities across geopolitical areas covered by the NGO's activities, and developing and strengthening strategic tools, operational policies, and guidelines for the purpose of improving the NGO's institutional capacity to deliver on its strategic goals and objectives. As part of the application, the NGO provided a list of required documentation covering, apart from the letter of application, list of board members, certificate of registration, signed articles of association, sources of funding, independent audited financial statement, December 2022, 2023 annual reports, and strategic plan 2023-2027. The application from the organization, whose main objectives and activities are in consonance with the fundamental principles and objectives enunciated in the African Union Constitutive Act and the African Charter on Human and People's Rights. And the analysis further states that the application contains all the relevant documents listed above as required under the Commission's resolution on the criteria for granting and enjoying observer status to NGOs working in the field of human and people's rights. The NGO is also registered and had an office in a state party to the African Charter, as mentioned above. In the light of the foregoing, the proposal is for this commission to grant observer status to Hope Inspired Foundation for Women and Youth with Disabilities. Thank you.
Commissaire Ederso pour présentation de cette requête de cette institution du Nigeria, Hope Inspired Foundation for Women and Youth with Disabilities. Commissaire, vous avez la parole pour vos observations. Je ne vois pas de demande de parole ni en ligne ni ici. Je pense que nous pouvons suivre la proposition faite par le commissaire rapporteur pays nous octroyons le statut d'observateur à Hope Inspired Foundation for Women and Youths with Disabilities. La prochaine structure, c'est Rwanda Men's Resources. C'est une ONG qui est basée au Rwanda. Et je vais encore donner la parole au commissaire Mwandenga. Pendant ce temps, si la commissaire Topsy Sono n'est pas en ligne, s'il n'est pas en ligne, je demande au secrétariat de donner ce... She's online? Oh, thank you very much. Mais de donner quand même le dossier de la commissaire Avomo qui n'est pas, s'est pas encore connecté à la commissaire Lita déjà, pour qu'elle puisse nous le présenter. Commissioner Mwandenga, you have the floor. You have the floor for the NGO from Rwanda. Number 8.
Thank you, Chair. I now present an application for observer status for Rwanda Men's Resource Center. We have been given their address, which is in Kigali, Rwanda. It was registered on the 11th April 2013, and the place of registration is the Republic of Rwanda. The date of the application that we are considering is 28th November 2023. This NGO, Rwanda Men's Resource Center, is a non-governmental organization based in Rwanda that is dedicated to promoting gender equality, women's rights, and social justice. The NGO focuses on promoting positive masculinity and male engagement approaches in preventing gender-based violence in Uganda. It is aimed to change masculinity norms of men and boys to become positive and supportive partners in promoting gender equality in Rwanda. The vision statement to create a peaceful society where women and men share roles, responsibilities in raising families and governing society through equality and respect. Mission to promote gender equality by transforming masculinity and feminism through awareness creation, advocacy, capacity development, movement building, and service delivery. The objectives are: 1, create awareness about gender equality among community members and local leaders. 2, partner and support community action groups to challenge unequal gender norms. 3, strengthen community level mechanisms for the prevention of sexual and gender-based violence in Rwanda. And 4, advocate for gender justice through mainstreaming of gender transformative and men-engaged approaches. The list of documents provided are a letter of application dated 28 November 2023, a list of board members, certificate of registration dated 11th April 2013, signed articles of association dated 6 April 2019, their sources of funding, independent financial statements as at December 2022, then the 2022 annual reports, and lastly but not the least, strategic plan 2022 to 2026. This application is from an organization whose objectives and activities are in consonance with the fundamental principles and objectives enunciated in the AU Constitutive Act and the African Charter on Human and People's Rights. The application contains all the relevant documents as required under the Commission's resolution and the criteria for granting and enjoying observer status to NGOs working in the field of human and people's rights. The NGO is registered and there is an office in a state party to the African Charter. The Secretariat recommends that in view of the above, the NGO be granted observer status. Upon consideration of the application and recommendation by the Secretariat, the Commission decides to grant the NGO Rwanda Men's Resource Center observer status. Thank you, Chair.
Merci, commissaire Mwandenga, pour votre présentation rapide et succincte. Mesdames et messieurs les commissaires, vous avez suivi la requête présentée par cette organisation non gouvernementale. Est-ce que vous avez des observations à formuler sur cette requête? Je ne vois pas, sauf votre avis contraire, comme il n'y a pas d'avis de non-objection. Nous accordons le statut d'observateur à Rwanda Men's Resource Center, la RWAM-REC. Et au nom de la Commission africaine, nous leur présentons, en tout cas, nous présentons à cette institution nos sincères félicitations. La prochaine organisation non gouvernementale, c'est Women's Legal Aid Center, WLAC, de la Tanzanie. Et ce dossier nous sera présenté par l'honorable commissaire Topsy Sono, qui est en ligne. Commissioner Topsy Sono, can you lead us in this file? Ethel? She's online? OK. Commissaire Topsy Sono, si vous êtes en ligne, prenez la parole. Commissaire Topsy Sono. Commissaire Topsy Sono. OK. Peut-être qu'elle a des difficultés techniques. On va passer à l'autre dossier en attendant qu'elle se connecte, parce qu'il nous reste 4 minutes pour prendre la pause. Commissioner Lita, can you please present the file for Ami de l'Angola? C'est un dossier qui devait être présenté par l'honorable commissaire Marie-Louise Abomo, qui n'est pas encore connectée. Can you present the file, please?
Thank you very much, Honorable Chairperson, commissioners present and online, distinguished delegates from state parties, national human rights institutions, and NGOs, staff of the Commission, interpreters, ladies and gentlemen. On behalf of Commissioner Honorable Marie-Louise Abomo, the country rapporteur for Angola, I will have the pleasure to present to you Friends of Angola for consideration. Friends of Angola was registered on 19th of November 2020 in the Republic of Angola. The application we have is dated 21st July 2023. Friends of Angola is an advocacy organization created to raise awareness of the challenges facing the international community and to support Angolan civil society. In response to the various challenges facing Angola, the Friends of Angola has grown considerably in size, scope, and reach, and has established a community radio station. Friends of Angola works with Angolan individuals and organizations seeking to address the many issues facing the country: human rights abuses, corruption, the promotion of democracy, and the rights and freedoms promised by the peace agreement with Angola. Its vision is to strengthen Angolan civil society in order to build a peaceful, democratic, and prosperous society. Its mission is to raise international awareness of the challenges facing Angola and to support Angolan civil society. The objectives of the NGO are: 1, to strengthen Angolan civil society on electoral issues, and 2, to strengthen democracy in Angola through community journalism. The organization submitted the following documents: an application letter, a list of NGO members, certificate of registration,
signed statutes, sources of funding, financial statements certified by an independent audit December 2021, and a strategic plan. Analysis of the Secretariat. This application comes from an organization whose main objectives and activities are in line with the African Charter on Human and People's Rights. The application contains all the relevant documents required by the Commission, resolutions on the criteria for granting and enjoying observer status to NGOs active in the field of human rights and people's rights. The NGO is registered in a state party to the African Charter on Human and People's Rights. The decision of the Commission. In view of the above, the Commission decides that observer status be granted to Friends of Angola. I submit, Chair.
Merci beaucoup, commissaire Lita, d'avoir présenté cette requête de Amis de l'Angola. Commissaire, est-ce que vous avez des observations? Non. Conformément aux pièces du dossier, à l'analyse qui a été faite, nous pensons que nous vous suivons dans cette demande de l'octroi du statut d'observateur à Amis de l'Angola. Au nom de la Commission et au nom de tous les collègues, je voudrais vous présenter nos sincères félicitations. Il reste un dossier. La commissaire Topsy Sono ne prend pas le téléphone. Can I ask you to Commissioner Lita to volunteer herself and to present the last file from Commissioner Topsy Sono? Women's
Chair,
Level.
can I be given 3 minutes?
Nous allons prendre la pause parce qu'il est 10h30. Can you present it, please? Thank you.
Thank you, Chair. I'm gladly stepping in for Commissioner Topsy Sono, who is not able to connect to present Women's Legal Aid Center from Tanzania. Your Excellencies, ladies and gentlemen, the Human Legal Aid Center was registered on the 4th of July, 2022. It was registered in the United Republic of Tanzania, and the date of its application is 13th December, 2023. The Women's Legal Aid Center is a non-governmental organization based in Tanzania that empowers women to attain their rights by providing legal assistance and legal aid to women and children in Tanzania. It is dedicated to promoting gender equality, women's rights, and social justice. The vision of the organization is to respect and promote women's and children's rights. The mission of the organization is to work towards promoting women and children's rights through civil and socio-economic empowerment, access to justice, and advocacy for pro-gender legal and policy frameworks in Tanzania. The objectives of the organizations are: 1, to provide legal aid services to women and children so as to safeguard their rights and improve their livelihoods. 2, to facilitate the establishment and strengthening of paralegal units across Tanzania to foster community-based education on legal and human rights and to improve timely access to quality legal aid. And 3, advocate for change of discriminatory policies, laws, and cultural practices which promote and sustain gender-based violence. The organization submitted all the documents required, namely a letter of application, secondly, list of board of members, thirdly, certificate of registration, fourthly, signed articles of association, fifthly, sources of funding, 6, independent audited financial statements dated December 2022, 7, annual report for 2022 and a strategic plan for 2021 to 2025. The analysis of the Secretariat. This application is from an organization whose main objective and activities are in consonance with the fundamental principles and objectives enunciated in the African Union Constitutive Act and the African Charter for Human and People's Rights. The application contains all the relevant documents as required under the Commission's resolutions and on the criteria for granting and enjoying observer status to NGOs working in the field of human rights and people's rights. The organization is registered as, and has an office in a state party to the African Charter. The decision of the Commission. In view of the above, the Commission decides that observer status be granted to Women's Legal Aid Center in Tanzania. I submit, Chair.
Merci beaucoup, Commissioner Milton Messini Organa. Mesdames et Messieurs les commissaires, au regard des pièces du dossier, il nous est proposé d'octroyer le statut d'observateur à cette institution de la Tanzanie. Est-ce que vous avez un commentaire, un avis d'objection à émettre sur cette question? Je ne vois pas de demande de parole. Au regard des pièces du dossier, le statut d'observateur est octroyé à Women's Legal Aid Center, WLC, et nous présentons à cette institution toutes les félicitations de la Commission africaine des droits de l'homme et des peuples. It's now time for break. We'll resume after 30 minutes. Et je voudrais féliciter tous les commissaires qui ont présenté le dossier et les juristes qui y ont travaillé. Nous allons donc suspendre les travaux pour un break, un petit break. Et nous rentrons dans 30 minutes. Il sera, je pense, 11h06. Banjul time. Merci.
I'm Solomon Ayele Derso. I'm a member of the African Commission on Human and People's Rights. I chair the working group on extractive industries, environment and human rights violations in Africa in the Commission. This is one of the mechanisms of the African Commission on Human and People's Rights, which is tasked with the responsibility of monitoring the human rights situation and environmental issues that arise in the extractive industries sector. As you all know, the extractive industry sectors historically, but also broadly speaking in Africa, has very substantial consequences on the lives, livelihoods, land, territories, as well as the environment of the African continent. While the extractive industry sector has enormous potential for contribution to the socioeconomic development and thereby the improvement of the living standard of people of the continent, more often than not, this potential of the extractive industry sector has not been felt in the lived experiences of most people on the continent. Contrary to this, the natural resources of the continent and the operation of the extractive industries has brought a great deal of suffering, a great deal of human rights violations, and also environmental degradations on many parts of the continent. In the context of the current rush for critical minerals and also what are called transition minerals, in the context of the green energy transition, there is another scramble for these rare minerals on the African continent. And in this context, our working group asked the question whether once again, as in the past, the continent is going to face the resource curse arising from this rush for critical minerals. So our work as the working group is to promote the respect for and observance of the human rights standards of the African Charter on Human and People's Rights, particularly as they relate to the exploitation and extraction of natural resources that the continent is enormously endowed with. Under Article 21 of the African Charter, specific obligations have been laid out. Actually, so much so that this is one of, if not the longest provisions of the Charter, highlighting the importance that is attached to and the historical significance of the natural resource exploitation of the African continent for the exclusive benefit of the people of the continent. With respect to the state of human rights on the African continent and broadly what we can do and should do, I think it's important to note that in terms of normative development, having the right norms relating to human rights, in terms of institution building, having the various institutions for the monitoring and implementation of human rights standards, a lot of progress have been made, both through the normative development contribution of the African Commission on Human and People's Rights and broadly by the African Union. Yet the gap between the promise of these various and progressive human rights norms and the lived realities of our people is ever increasingly expanding. We have to feel the urgency and we have to feel the gravity of what the vast majority of people on our continent is feeling. The higher the gulf between the promise of human rights and the lived realities of our people, the higher the challenge for appreciating the relevance of our work and the role of the Commission. We therefore need to work hard in order to harness the role and contribution of all sectors of society in order to narrow down this enormous gulf between the promise of our norms and the lived realities of the people on the continent. That is why it's extremely important for the Commission to work with other sectors of society beyond and above human rights institutions, human rights, NGOs, and civil society organizations. The role of the media needs to be harnessed, and to be harnessed enormously. The role of policymakers, particularly in the economic sphere, needs to be harnessed. The role of policymakers in other areas, the digital space, also needs to be appreciated and harnessed and taken advantage of. We have to use civil society organizations, use women, and the enormous potentials and entrepreneurial skills of our people. I thank you very much.
I am Honorable Farah Maalim from the Kenyan National Assembly. I attended the African Commission for Human and People's Rights conference in Dakar, Senegal. It's important for us to face some of these challenges of the modern days as a continent together. It's very important that the continent that moves together. We don't want to get into a situation in which certain parts or regions of the continent make leaps and strides in attaining human and people's rights, and certain parts also suffering the scourges of the extreme violations of their basic human and people's rights. So I think this conference was very good, and we have agreed on a number of things. And one of it is to domesticate the Commission's work so that they work with very grassroots-based people, rural folks. This does not have to become an elitist kind of a body where people meet only in capital cities and where lawyers, engineers, and doctors are the ones who contribute. It's important for them to understand the problems, the human rights problems of the peoples in the very, very, simple and very humble rural settings. It's also important that Africa wakes up to the realization that we have historical injustices that were done to us. Injustices in the form of slavery, colonization and neo-colonization, the extraction and exploitation of the raw minerals and resources of the African continent. And the people who are responsible for that are known. It's the first world. They must be able to prepare themselves for reparations as well as compensation. Thank you.
मुझे ऐसा लगा कि भगवान ने मुझे छोड़ा। पता लगा कि मेरे अंदर एंजाइटी सी बीमारी है, तो मुझे ऐसा लगा कि भगवान ने मुझे छोड़ा। तो मुझे ऐसा लगा कि भगवान ने मुझे छोड़ा। पता लगा कि मेरे अंदर एंजाइटी सी बीमारी है, तो मुझे ऐसा लगा कि भगवान ने मुझे छोड़ा। पता लगा कि मेरे अंदर एंजाइटी सी बीमारी है, तो मुझे ऐसा लगा कि भगवान ने मुझे छोड़ा।
Maximilienne Gombe, c'est mon nom. Je suis la directrice exécutive du réseau des défenseurs des droits humains en Afrique centrale, le RIDAC. On couvre 8 pays de l'Afrique centrale, en dehors du Burundi et du Rwanda. Alors, pour nous, la Commission africaine des droits de l'homme et des peuples, c'est un instrument efficace pour la protection et la promotion des droits humains qui a donné un espace, n'est-ce pas, aux OSC, aux ONG. Et nous sommes très, très, très fiers aujourd'hui d'être là pour le premier forum. Ce que nous recommandons, c'est que les États parties donnent un peu plus de moyens, rendent la Commission indépendante, un peu plus de moyens financiers, parce que sans moyens financiers, il n'est pas possible de continuer, n'est-ce pas, d'aller dans toute l'Afrique pour promouvoir et protéger les droits humains. Merci.
ميمونة السيد رئيسة اللجنة الجهوية لحقوق الإنسان بجهة الداخلة وادي الذهب. نحن اليوم نشارك في الملتقى الأول الخاصة بحقوق الإنسان. المجلس الوطني لحقوق الإنسان باعتباره مؤسسة وطنية تعنى بحماية والنهوض بثقافة حقوق الإنسان على المستوى الوطني وعلى مستوى كذلك الدولي. إذن باعتباره كذلك آلية تساهم بمعية مجموعة من الشركاء في التتبع تنزيل السياسات العمومية ومدى ملائمتها مع التشريعات الوطنية وكذلك المواثيق الدولية. الملتقى يشكل فرصة يعني فريدة من نوعها من أجل تبادل التجارب من طرف كل الفاعلين في مجال حقوق الإنسان من مختلف دول القارة الإفريقية، وهو كذلك يشكل فرصة للترافع عن قضايا حقوق الإنسان إما على المستوى الجهوي الوطني أو الدولي.
I'm Solomon Ayele Dersa. I'm a member of the African Commission on Human and People's Rights. I chair the working group on extractive industries, environment and human rights violations in Africa in the Commission. This is one of the mechanisms of the African Commission on Human and People's Rights, which is tasked with the responsibility of monitoring the human rights situation and environmental issues that arise in the extractive industries sector. As you all know, the extractive industry sectors historically, but also broadly speaking in Africa, has very substantial consequences on the lives, livelihoods, land, territories, as well as the environment of the African continent. While the extractive industry sector has enormous potential for contribution to the socioeconomic development and thereby the improvement of the living standard of people of the continent, more often than not, this potential of the extractive industry sector has not been felt in the lived experiences of most people on the continent. Contrary to this, the natural resources of the continent and the operation of the extractive industries has brought a great deal of suffering, a great deal of human rights violations, and also environmental degradations on many parts of the continent. In the context of the current rush for critical minerals and also what are called transition minerals, in the context of the green energy transition, there is another scramble for these rare minerals on the African continent. And in this context, our working group asked the question whether once again, as in the past, the continent is going to face the resource curse arising from this rush for critical minerals. So our work as the working group is to promote the respect for and observance of the human rights standards of the African Charter on Human and People's Rights, particularly as they relate to the exploitation and extraction of natural resources that the continent is enormously endowed with. Under Article 21 of the African Charter, specific obligations have been laid out. Actually, so much so that this is one of, if not the longest provisions of the Charter, highlighting the importance that is attached to and the historical significance of the natural resource exploitation of the African continent for the exclusive benefit of the people of the continent. With respect to the state of human rights on the African continent and broadly what we can do and should do, I think it's important to note that in terms of normative development, having the right norms relating to human rights, in terms of institution building, having the various institutions for the monitoring and implementation of human rights standards, a lot of progress have been made, both through the normative development contribution of the African Commission on Human and People's Rights and broadly by the African Union. Yet the gap between the promise of these various and progressive human rights norms and the lived realities of our people is ever increasingly expanding. We have to feel the urgency and we have to feel the gravity of what the vast majority of people on our continent is feeling. The higher the gulf between the promise of human rights and the lived realities of our people, the higher the challenge for appreciating the relevance of our work
and the role of the commission. We therefore need to work hard in order to harness the role and contribution of all sectors of society. Narrow down this enormous, the promise of our norms and the lived realities of the people on the continent. That is why it's extremely important for the Commission to work with other sectors of society beyond and above human rights institutions, human rights NGOs and civil society organizations. The role of the media needs to be harnessed, and to be harnessed enormously. The role of policymakers, particularly in the economic sphere, needs to be harnessed. The role of policymakers in other areas, the digital space, also needs to be appreciated and harnessed and taken advantage of. We have to use civil society organizations, use women and the enormous potentials and entrepreneurial skills of our people. I thank you very much.
I'm honored as the ambassador of Somalia to Ethiopia and AU to join the platform which brought together stakeholders across the continent to foster dialogue and exchange views as we assess the challenges in achieving aspirations 3 of Agenda 2063, an Africa of good governance, respect for human rights, justice, and rule of law. The final declaration of the forum called on exclusive and dialogue, including non-governmental actors, researchers, and senior expertise, so that we will have a society with human rights advocacy. So this was a platform that brought all stakeholders from non-governmental organizations, human rights activists, and also member states. It was very fruitful and very productive discussions for the last 3 days, and we are grateful for the outcome of that. Thank you very much.
I'm Eric Mundia, Policy and Advocacy Manager at IPAS Africa Alliance. We work to support women reproductive health rights in Africa. This session has been very good. It's the first joint session of the SHPR. It has been an incredible 3 days sharing with the commissioners, with other stakeholders, state parties, and like-minded CSOs. This has been a position of reflection on what needs to be done, what are the next steps, and also to look back at some of the great strides that we have made. We hope to see you next time in the next session, where we shall share more and also deliberate on how to make African people's human rights situation better. Thank you.
मुझे ऐसा लगा कि भगवान ने मुझे दूसरा
My name is Wangeshi Grace Kahuria. I'm the Executive Director of the Independent Medical Legal Unit, which is a national civil society organization based in Kenya. I am attending the first joint session of the African Commission on Peoples and Human Rights, and it is indeed a great opportunity for the Commission, for civil society, for governments to sit and talk around issues pertaining to human rights and the status of human rights in Africa. I do want to acknowledge that this has been a great space to share our thoughts, to share our experiences, to share and articulate issues around the status of human rights in Africa. Now, what I'm taking home is the importance of leveraging on the different mandates of the different levels of governance within the Africa Commission, but also the relationship between civil society, the academia, and the Commission. Of great importance is a convening space that the Commission brings, the fact that it is able to gather all of us from Africa to a session where we can discuss without fear, we can discuss without any form of intimidation, we can discuss from the realities of the organizations and the spaces that we serve. And we do realize that the provisions of the different international instruments, the different protocols provide for us the legal impetus on how to manage, to monitor, to report on human rights in Africa. Now, coming from Kenya, I really are delighted that Kenya is one of the countries that has submitted its reports, the state reports on human rights, and I think that is a fundamental, that's fundamental progress that the country has made. However, it's not just about submission of reports, it's about articulation of human rights in the country. IMLU is an organization that focuses on issues around torture, on issues around the right to picket, the right to assembly, the right to association, the right to expression. And from our work and from the conversations that we've had, from the monitoring that we have had, we note that this is a space that requires a lot more work. And so the question is, how do we get the support of the Commission to make sure that these issues are brought to the fore and to the light of the country so that commitments are made to address this issue? And so this is an important space, and I do want to appreciate that a lot of progress has been realized, and we can take it forth in the next session.
Yes, my name is Dr. Isaac Anan. I represent the Parliament of Ghana. In terms of what I can say about the forum so far, I can say it's been very, very insightful. It has been cross-fertilization of ideas from various organizations, including state and non-state actors. In terms of the mandate or the work of the Commission, I think basically as a commission that promotes and protects human rights, it has become clear that it needs to do more in terms of trying to deepen the knowledge of various actors or various stakeholders in terms of human rights, promotion and protection by making sure that the various countries that form the commission, the member states, in terms of their legal education and education to judicial officers, especially judges, are deepened so that it will enhance the promotion and protective mandate of the commission.
ميمونة السيد رئيسة اللجنة الجهوية لحقوق الإنسان بجهة الداخلة وادي الذهب. نحن اليوم نشارك في الملتقى الأول للآليات الخاصة بحقوق الإنسان كمجلس وطني لحقوق الإنسان، باعتباره مؤسسة وطنية تعنى بحماية والنهوض بثقافة حقوق الإنسان على المستوى الوطني وعلى المستوى كذلك الدولي. إذن باعتباره كذلك آلية تساهم بمعية مجموعة من الشركاء في التتبع تنزيل السياسات العمومية ومدى ملائمتها مع التشريعات الوطنية وكذلك المواثيق الدولية. الملتقى يشكل فرصة يعني فريدة من نوعها من أجل تبادل التجارب من طرف كل الفاعلين في مجال حقوق الإنسان من مختلف دول القارة الإفريقية، وهو كذلك يشكل فرصة للترافع عن قضايا حقوق الإنسان إما على المستوى الجهوي الوطني أو الدولي.
मुझे ऐसा
I'm honored as ambassador of Somalia to Ethiopia and AU to join the platform which brought together stakeholders across the continent to foster dialogue and exchange views as we assess the challenges in achieving aspirations 3 of Agenda 2063, an Africa of good governance, respect for human rights, justice, and rule of law. The final declaration of the forum called on exclusive and dialogue, including non-governmental actors, researchers, and senior expertise, so that we will have a society with human rights advocacy. So this was a platform that brought all stakeholders from non-governmental organizations, human rights activists, and also member states. It was very fruitful and very productive discussions for the last 3 days, and we are grateful for the outcome of that. Thank you very much.
My name is Wangeshi Grace Kahuria. I'm the Executive Director of the Independent Medical Legal Unit, which is a national civil society organization based in Kenya. I am attending the first joint session of the African Commission on Peoples and Human Rights, and it is indeed a great opportunity for the Commission, for civil society, for governments to sit and talk around issues pertaining to human rights and the status of human rights in Africa. I do want to acknowledge that this has been a great space to share our thoughts, to share our experiences, to share and articulate issues around the status of human rights in Africa. Now, what I'm taking home is the importance of leveraging on the different mandates of the different levels of governance within the Africa Commission, but also the relationship between civil society, the academia, and the Commission. Of great importance is a convening space that the Commission brings, the fact that it is able to gather all of us from Africa to a session where we can discuss without fear, we can discuss without any form of intimidation, we can discuss from the realities of the organizations and the spaces that we serve. And we do realize that the provisions of the different international instruments, the different protocols provide for us the legal impetus on how to manage, to monitor, to report on human rights in Africa. Now, coming from Kenya, I really are delighted that Kenya is one of the countries that has submitted its reports, the state reports on human rights, and I think that is a fundamental, that's fundamental progress that the country has made. However, it's not just about submission of reports, it's about articulation of human rights in the country. IMLU is an organization that focuses on issues around torture, on issues around the right to picket, the right to assembly, the right to association, the right to expression. And from our work and from the conversations that we've had, from the monitoring that we have had, we note that this is a space that requires a lot more work. And so the question is, how do we get the support of the Commission to make sure that these issues are brought to the fore and to the light of the country so that commitments are made to address this issue. And so this is an important space, and I do want to appreciate that a lot of progress has been realized, and we can take it forth in the next session.
I'm Eric Mundia, Policy and Advocacy Manager at IPAS Africa Alliance. We work to support women reproductive health rights in Africa. This session has been very good. It's the first joint session of the SHPR. It has been an incredible 3 days sharing with the commissioners, with other stakeholders, state parties, and like-minded CSOs. This has been a position of reflection on what needs to be done, what are the next steps, and also to look back at some of the great strides that we have made. We hope to see you next time in the next session where we shall share more and also deliberate on how to make African people's human rights situation better. Thank you.
Yes, my name is Dr. Isaac Annan. I represent the Parliament of Ghana. In terms of what I can say about the forum so far, I can say it's been very, very insightful. It has been cross-fertilization of ideas from various organizations, including state and non-state actors. In terms of the mandate or the work of the Commission, I think basically as a commission that promotes and protects human rights, it has become clear that it needs to do more in terms of trying to deepen the knowledge of various actors or various stakeholders in terms of human rights, promotion and protection, by making sure that the various countries that form the commission, the member states, in terms of their legal education and education to judicial officers, especially judges, are deepened so that it will enhance the promotion and protective mandate of the Commission.
Maximilienne Gombe, c'est mon nom. Je suis la directrice exécutive du réseau des défenseurs des droits humains en Afrique centrale, le REDAC. On couvre 8 pays de l'Afrique centrale, en dehors du Burundi et du Rwanda. Alors, pour nous, la Commission africaine des droits de l'homme et des peuples, c'est un instrument efficace pour la protection et la promotion des droits humains qui a donné un espace, n'est-ce pas, aux OSC, aux ONG. Et nous sommes très, très, très fiers aujourd'hui d'être là pour le premier forum. Ce que nous recommandons, c'est que les États partis donnent un peu plus de moyens, rendent la Commission indépendante, un peu plus de moyens financiers, parce que sans moyens financiers, il n'est pas possible de continuer, n'est-ce pas, d'aller dans toute l'Afrique pour promouvoir et protéger les droits humains. Merci.
ऐसा लगा कि भगवान ने मुझे छोड़ा।
Ethel, can we go online? Thank you very much. Mesdames Mesdemoiselles et Messieurs, nous allons donc reprendre les points qui sont inscrits à notre agenda. Et pour l'instant, nous allons revenir au point 3, la situation des droits de l'homme en Afrique. Human Rights Situation in Africa. Je vais appeler quelques organisations. Je commence par le National Human Rights Institutions. J'appelle Ethiopian Human Rights Commission. Rakeb Mesele, numéro d'affiliation 18. Rakeb Mesele. Est-ce qu'ils sont en ligne? Rakeb Mesele. Rakeb Mesele. Ethel.
Good morning.
You're online?
Can you hear me?
C'est Albab. C'est Miss Albab who will speak on behalf of the chairperson of the Ethiopian Human Rights Commission. Albab, if you are online, you can take the floor.
Hello, can you hear me?
Yes, we can hear you.
Okay. Good morning, good afternoon, everyone. This is actually Rakeb. So let me start my statement. Honorable Commissioner Remi Lumbu, Chairperson of the African Commission, Honorable Commissioner Mutford Muadenga, Country Rapporteur for the Human Rights Situation in Ethiopia, Honorable Commissioners, distinguished ladies and gentlemen, the Ethiopian Human Rights Commission is pleased to present the statement on the human rights situation.
Albab, can you speak close to the mic because we have some issues of interpretation? Close to the mic.
Can you hear me?
Okay, wait a second.
Hello. Can you hear me?
Abin, vous êtes prêt? Okay, Albab, go on. Albab,
Hello, can you hear me?
Abin, ça va? Wait, Ethel, can you solve the problem?
Hello, can you hear me?
Wait, Albab.
Hello, can you hear me?
Yes, you can now start.
Okay. So, Honorable Commissioner Remi Lumbu, Chairperson of the African Commission, Honorable Commissioner Mutford Muadenga, Country Rapporteur for the Ethiopian Human Rights, the human rights situation in Ethiopia, Honorable Commissioners, distinguished ladies and gentlemen, the Ethiopian Human Rights Commission is pleased to present the statement on the human rights situation in Ethiopia during this 79th ordinary session. Honorable Chairperson, the following are some of the key positive developments during the reporting period. In April 2024, the country's Council of Ministers adopted the Transitional Justice Policy of Ethiopia. The policy provides strategic direction to guarantee criminal accountability, establish the truth, provide reparation to victims, and ensure non-recurrence of violations. Recently, the federal government announced that 1.5 billion birr has been allocated to pay 18 months of outstanding pension payment for pensioners in Tigray. Additionally, the recently established Central Ethiopia and South Ethiopia regions have allocated funds for the effective establishment and functioning of Regional Federation of Association of Persons with Disability. Following the peace agreement signed between the federal government and the Tigray People's Liberation Front, some unlawfully detained individuals have been released, and there are efforts to reconstruct and reoperationalize damaged prison and detention facilities in Tigray region. In relation to Ethiopia's compliance with its reporting obligation, in the period under discussion, the country submitted the 7th to 10th combined periodic state report on the implementation of the African Charter and the initial report on the Maputo Protocol. Honorable Chairperson, there have also been some concerning development during the reporting period. EHRC's monitoring found that extrajudicial killing has been committed by state security forces, particularly in Amhara, Benishangul Gumuz, and Oromia regions. EHRC has confirmed that in January 2024, state security forces committed extrajudicial killings of at least 45 civilians in Marawi town in Amhara region. Additionally, in October 2023, over a dozen civilians were killed in a drone attack and heavy weapon attacks in the region. In Benishangul Gumuz region, in November 2023, an attack by armed groups resulted in the death of 17 individuals and serious injuries to 7 others. In Oromia region, in the same month, an unidentified gunman killed 10 individuals, including 7 members of a same family. EHRC also found that in 4 locations in South Ethiopia region, clashes with security forces in October and November resulted in property destruction, death, and physical injuries to civilian and security forces. EHRC also documented incidents of enforced disappearance and incommunicado detentions, particularly in Addis Ababa city and Amhara and Oromia regions. The lack of criminalization of enforced disappearance continues to be a challenge to address violation and to ensure that victims access justice. Arbitrary arrest and detention were also documented in several locations in the Amhara, Oromia, and Sidama regions, as well as in Addis Ababa city. The Ethiopian Human Rights Commission is concerned about the harassment, arrest, and detention of journalists, members of opposition political parties, staff of civil society organizations, and human rights defenders, which has worsened in the context of the state of emergency that has been in effect since August 2023. And in the context of the state of emergency, there has been cases of detention in unknown and undisclosed locations, violation of visitation rights by family and lawyer, and poor condition of detention, which could amount to ill treatment. While there has been an increase in the budget allocated for prisons, the amount is still inadequate. There are also over 3.4 million displaced persons as of September 2023, and internally displaced older persons and persons with disability do not receive adequate and need-based humanitarian support. Recent assessment, consultation, and monitoring conducted by the Ethiopian Human Rights Commission in various regions indicate an increase in harmful traditional practices, particularly early marriage and female genital mutilation. EHRC's monitoring in post-conflict Tigray and Afar and Benishangul Gumuz regions show the alarming consequence of health services interruption, such as limited vaccination leading to the resurgence of several illnesses and the occurrence of preventable diseases, death. Economic contraction, rising prices of basic commodity coupled with conflict in some regions have significantly impeded the realization of the right to education, work, food, and health. The education sector has been significantly impacted by conflict and floods, leading to damage and non-functional school facilities and millions of children's missing school. Yes.
Vous pouvez conclure. Dernière phrase.
Okay, so in view of the identified concern, the Commission present the following recommendation to the Ethiopian government to take prompt measures to independently investigate incidents of extrajudicial killing, comply with international humanitarian law on the conduct of parties to an armed conflict, immediately end hostilities, enabling space to be opened and for genuine dialogue and sustainable and inclusive peace. And with regard to the African Commission, support the Ethiopian government to maintain its commitment under the African Charter, and also support the government to effectively implement the country's transitional justice policy.
Merci beaucoup. Le commissaire Medford Mwandenga va prendre cette note et vous restez en contact avec lui pour les différents points que vous y avez développés. J'appelle Zimbabwe Human Rights Commission, Fungai Jessie Majom, numéro d'affilié 28. Zimbabwe Human Rights Commission. Tu es là online? Hein? C'est Charai. Eritrea, Human Rights Commission, the country. En attendant que l'on procède aux vérifications nécessaires, on reviendra sur la liste des États. Hein. On me dit qu'il y a l'Érythrée qui est en attente. On est en train d'attendre les statements. Nous allons revenir sur les États dans quelques minutes. They have been waiting. Do you have the statement? Okay. If we have received the statement, est-ce que can you verify, please? Eritrea delegation, they are online? Okay, thank you very much. If the delegation of Eritrea is online, they can take the floor for 7 minutes.
Thank you, Mr. Chairperson, Honorable Chairperson. All protocols observed. It gives me a great pleasure to update the 79th session of the SHPR on the progress achieved and the challenges faced by Eritrea in promoting and protecting human and people's rights. As a result of the relentless efforts by the people and government of Eritrea to safeguard and promote human rights, tangible achievements have been recorded across several sectors. At the African Union theme of 2024 is Educate an African Fit for the 21st Century, building resilient education systems for increased access to inclusive, lifelong, quality, and relevant learning in Africa. The statement focuses on education while covering a few other sectors as well. Mr. Chairperson, the people and government of Eritrea believes that education is the foundation of development, and that to provide equal educational opportunity means to provide equal opportunity for development. As a result, Eritrea's development agenda considers the education sector as a top priority. In this vein, education is universal and provided for free from kindergarten to tertiary level, and primary education is mandatory. The literacy rate now stands at 85%, and efforts are underway to make it universal in the near future. Eritrea is committed to increasing access to education for girls at all levels, and consequently reducing gender disparity. As a result of various schemes implemented, retention rates among female students have increased significantly. Currently, female students constitute nearly half of the total student population in institutions of higher education. Several measures have been taken to improve the participation, retention, and achievement of children in education, which includes increasing awareness among parents about the importance of keeping their children in school, improving feeding programs in schools, encouraging girls and young women to recognize and reward exemplary and successful ones, and conducting motivational campaigns. The government of Eritrea is continuing its efforts to expand opportunities for inclusive education for children with disabilities, among others through training of teachers and providing adequate facilities for the children. Citizenship education and education for sustainable development are mainstreamed and integrated within different aspects of the national education system. Technical and vocational education has increased through the formal system and through our workplace-based training. In order to enhance the quality of education, the government provides continuous pre-service and in-service trainings to upgrade the professional competency of teachers and school administrators. Eritrea managed to expand access to education to all sectors of the society and improve quality inter alia through construction of new schools, reviewing curriculum, and enhancing the capacity of teachers. Mr. Chairperson, the government of Eritrea has mainstreamed its focus on improving access to and quality of healthcare in the country. The programs and policies remain aligned with Africa's Agenda 2063 and the SDGs. Public health services are heavily subsidized. Patients are required to make only nominal payments, while the services are free for those who cannot afford to pay. The national health infrastructure has increased 3.7-fold from 93 in 1991 to 347 as of December 2023. By complementing this with an elaborate network of all-weather rural roads, 70% of the population now lives within a 5-kilometer radius of a functioning health facility. Disease remedy and prevention have increased manifold. Disease incidence decreased significantly, and the average life expectancy at birth stood at 67.7 years in 2023, with almost 20 years increase from that of 1991. Due to the substantial investments Eritrea has made in its public health system, the country has gone a long way in improving quality of and access to healthcare. Honorable Chairperson, in the sector of agriculture and food security, the Ministry of Agriculture has launched a strategic development plan for 2024-2028 period. The plan has the goal of ensuring safe and nutritious food for everyone, everywhere. In the justice sector, last month, the Ministry of Justice of Eritrea conducted a dialogue session focused on integrating Eritrean values into the country's legal framework as part of the ongoing efforts in legal reform for sustainable development. The focus was Eritrean values while also considering African and global perspectives. Honorable Chairperson, the encouraging progress Eritrea registered in promoting and protecting human and people's rights showcased above are achieved within the context of natural challenges such as drought and environmental problems associated with climate change, and man-made challenges such as the continued illegal sanctions imposed on Eritrea by the US and EU, instability and volatility at regional and international levels, and the unjust international system which oppresses and marginalizes developing countries. On its part, Eritrea duly recognizes the importance of peace and security and thus is exerting efforts in collaboration with its neighboring countries to promote peace and security in the Horn of Africa and Red Sea regions. Eritrea continues to advocate for a just and fair international system that benefits all peoples of the world. In conclusion, I wish to reiterate Eritrea's firm commitment for the promotion and protection of human and people's rights and for consolidating constructive engagements with SHPR. I thank you.
Merci beaucoup, Excellence, Monsieur l'ambassadeur Binyam. Nous avons pris bonne note de la déclaration et ces développements positifs qu'il y a dans cette note. La commissaire Lita Moussini Ogana, qui est commissaire rapporteur, si je ne me trompe pas, de l'Érythrée, va exploiter cette note. Mais permettez-moi, Monsieur l'ambassadeur, suivant le rapport que j'ai du secrétariat, nous attendons encore le document de réponse au rapport, à cet important rapport que vous aviez soumis à la 77e session ordinaire à Arusha, ce qui va nous permettre d'adopter les observations conclusives et les recommandations que nous sommes obligés de donner à l'Érythrée. Peut-être que je vais demander à la rapporteure pays Lita Moussini Ogana de continuer à suivre pour que ce document nous parvienne dans les meilleurs délais pour nous aider à formuler les observations finales sur ce rapport-là. Merci beaucoup. Vous êtes un ami de la commission. Vous participez toujours à nos travaux depuis de longues années, en virtuel ou en présentiel. Nous vous en sommes gré. Je vais retourner sur la liste des National Human Rights Institution. They told me that Zimbabwe Human Rights Commission, they are online. They are online. They say they are waiting in a waiting room. Can you advise, please? You don't see them, huh? Okay, thank you. Thank you. If you don't see them, we'll call them after. We move with the list. We continue with the list. Je passe maintenant à la liste des NGOs. J'appelle Anna Foster, le Centre pour la démocratie et les études en matière de droits de l'homme. Si elle est en ligne, pour 5 minutes. Madame Anna, vous êtes en ligne? OK. Madame Foster, 5 minutes. Madame Foster?
Yes, please. Thank you very much, Chairperson of the African Commission on Human and People's Rights, Vice Chairperson, Chairperson of the African Commission on Human and People's Rights, Vice Chairperson, members of the African Commission, state delegates, National Human Rights Institution representatives, representatives of civil society. I have been asked to share some highlights from our meeting, and I will move quickly to share that yes, in the 3 days we had an inaugural panel which looked at the state of human rights education from the broader point of education. And we had a Minister of Education of the Gambia make presentations to us. And it was very useful in that he highlighted the empowering essence of education, despite persistent challenges, including generally environments not conducive to the tasks given, such as inadequate infrastructure, outdated curriculum, lack of quality education, limited resources, teacher-student ratio, and the list goes on. Advocated for equality, equitable access to education for girls and rural youth. And perhaps I also need to highlight the fact that we looked at the situation of human rights and democracy in Africa. And the 5 regional focal points have indicated that the landscape of political instability continues, electoral misconduct, security crisis, violations of human rights, and challenges to democracy. The 4 freedoms of expression, association, assembly, and opinion, and the shrinking civic space is indeed on the very high on the list. We've also been advised on formulation of repressive human rights law in violation of freedom of association and assembly reported in Angola and in Zimbabwe. So it will be, we are asking the African Commission to urge states to review these laws that tend to create challenges for human rights defenders, particularly in the area of freedom of association and assembly. We also would like to highlight the fact that electoral delays and democratic regression in Africa continues. Africa is at a crossroads, pushback constantly tested, the resilience of civil society with political suppression of dissent, widespread electoral fraud reported in some nations, and there are flaws in democracy and failure to respect presidential term limits, military takeovers in some of these countries, and this, we call it disrespect for sub-regional economic communities, which also create instability in some of these countries. We also looked at building inclusive education systems for persons with disability. And we got the people who are affected themselves on the panel. And they are advocating for inclusiveness in mainstreaming education and rejecting the notion of segregating them into schools. And emphasize that education is a pathway to empowerment for these persons with disability. And as such, they should be given the opportunity to access education. There is also, however, lack of empirical data and also the political will. Lack of political will is evident in many countries. There is need for evidence-based advocacy and political policy reforms to ensure inclusive education for persons with disability. We also wanted to look at the fact that the protocol to the Charter on Human and People's Rights on specific aspects of the right to a nationality and the eradication of statelessness. And this particular protocol, we felt that there is need for more advocacy and we have to work to ensure that it enters into force so that these people who are suffering from lack of documentation and have not been able to access the pathway to of nationality to at birth or later in life will be able to do so. So we would like to request that the African Commission call on states to ratify and also to ensure that African civil society get engaged in the advocacy processes so that the ratification can be accelerated and entry into force for implementation to take place. There was also one particular panel that was also very important and interesting. And that panel was looking at communities discriminated based on work and descent. And during the forum, the reports were launched on the Gambia, in Cameroon, in Niger, and in Mali, in Mauritania. Four of those reports were launched. And in each of those reports, it was evident that there is a persistent of modern day slavery in some of these countries. And the importance of calling on advocacy for legal frameworks which safeguard the rights of affected individuals and prioritize their access to education. It is also important that data is collected and a comprehensive monitoring systems by African Commission to put in place and make sure that priority for states should be to include relevant information, relevant education, such as climate change and environmental education in the curriculum. So that it helps them to be better prepared to face these challenges. Collective action and international support to combat discrimination and promote inclusivity and equality should be encouraged. States should be encouraged to put those in place. There was also a panel that looked at protection of human rights by UN mechanisms and regional judicial and quasi-judicial bodies. And it highlighted the role of ECOWAS Court of Justice in arbitrating disputes among member states and enforcing community protocols with a broad range of access for cases involving human rights violations and international dimensions. And during the discussion, it was recommended that there should be more collaboration between such economic communities with the African Commission, because states do present their state reports to the African Commission and should be in a position to interrogate any discrepancy or that takes place in terms of states not fulfilling their obligations to these courts.
Conclusion?
Okay, in conclusion, perhaps I just need to highlight the fact that we had 5 country resolutions which will be shared on Chad, on DRC, Eswatini, Sudan, and Zimbabwe. And also special in the thematic recommendations on peace building, on GBV, gender-based violence, on migration, on freedom of association and assembly, and discrimination based on work and dissent. I thank you for your kind attention.
Merci, Madame Anna Foster, pour cette déclaration. Nous avons la note. La Commission va l'exploiter et surtout puiser les belles idées, les bonnes propositions qu'il y a dedans. Je reviens un peu en arrière sur la liste des INDH. Zimbabwe Human Rights Commission. Zimbabwe Human Rights Commission. 5 minutes. Zimbabwe.
Thank you very much, esteemed chairperson and commissioners, to the chairperson, the deputy chairperson, and the commissioners of the African Human Rights Commission, state delegates, fellow national human rights institutions, and distinguished delegates, all protocol observed. The Zimbabwe Human Rights Commission takes this opportunity through myself, the chairperson, Fungai Jesima Jome. I want to apologize that the registration indicates my name as someone else. I'm honored to have this opportunity to thank the African Commission on Human and People's Rights for awarding us the opportunity to report on the human rights situation in Zimbabwe since the last submission. We acknowledge with the immense role that you play in the context on the enjoyment of human rights. The Zimbabwe Human Rights Commission is proud to provide that it was re-accredited as an A-status national human rights institution by the Global Alliance of National Human Rights Institutions, GANRI. It is mandated to assess the enjoyment of human rights and freedoms, to receive and investigate alleged violations of human rights and administrative justice, and to carry out awareness raising on human rights. On the enjoyment of civil and political rights, Mr. Chairman, the Zimbabwe Human Rights Commission takes note that Zimbabwe continues to uphold the tenets of democracy in conducting regular elections, with the holding of the 2023 synchronized and quadruplicate elections. The last elections before then were held in 2018. The 2023 elections were conducted in a peaceful environment. In its report, the Zimbabwe Human Rights Commission noted that there were allegations of intimidation of voters, isolated incidences of violence perpetrated by some political parties and actors, partisan distribution of food aid and vote buying, amongst other electoral malpractices. The Zimbabwe Human Rights Commission continues to work with different stakeholders such as government, civil society organizations, political parties, and the general public towards a society tolerant of divergent views, and to urge political parties and players to coexist peacefully without threats and intimidation which can affect the enjoyment of political rights. The Zimbabwe Human Rights Commission notes that the enjoyment of economic, social, and cultural rights has been marred by increased poverty among communities. The formal sector continues to face erosion of incomes and pensions, which is further exacerbated by inflation, which has been with the country for a long time now. Although the informal sector has absorbed those who have failed to find employment, it continues to bear the brunt of uncertainty on the market due to the illegality of their operations, and does not afford safe work. Despite the foregoing, the Zimbabwe Human Rights Commission notes the efforts in place to stabilize the economy through the newly enunciated monetary policy and the new currency called the ZIG, or the abbreviation for Zimbabwe Gold, and hopes that these efforts will lead to more disposable incomes for the populace. More needs to be done to address the economic challenges facing communities and households in rural, peri-urban areas, so as to protect the livelihoods and socio-economic rights of citizens. The Zimbabwe Human Rights Concern notes the efforts made by the government of Zimbabwe in improving access to healthcare, including the vaccination drive for children under 10 years of age, as well as the frequent programs for polio drops to avert poliomyelitis. However, the Commission remains concerned with outbreaks of cholera in Zimbabwe. The Commission noted from its assessments that efforts were being made to vaccinate against cholera and raise awareness in communities on ways of preventing its spread. The Zimbabwe Human Rights Commission has taken note that in recent months, the country has recorded no new cases of cholera and applauds the Zimbabwe government for its efforts. The Commission encourages government to ensure that programs continue to be carried out to eliminate the threat of cholera through vaccinations and ensuring a clean environment, and more importantly, access to permanent access to clean, potable water. The Zimbabwe Human Rights Commission congratulates the government of Zimbabwe on the submission of outstanding reports to treaty bodies such as of the African Charter on the Rights and Welfare of the Child, which was considered during the 43rd session of the African Committee of Experts on the Rights of the Child in April 2024 in Lesotho. The ZHRC urges the Zimbabwe government to submit outstanding reports and fully meet the obligations under the treaty body mechanisms. In addition, the Zimbabwe Human Rights Commission urges the government to ratify all outstanding core human rights instruments for the benefit of the human rights and freedoms of the Zimbabwe populace. The Zimbabwe Human Rights Commission is pleased with the drive to enact positive legislation to protect the rights of vulnerable groups.
Thank you very much, Dylan. Thank you
Zimbabwe,
very much.
the
Yeah.
enactment
Dylan?
Children Amendment Act, I believe maybe it's the Zimbabwe Human Rights Commission chair that is registered as Dylan, possibly. Maybe my time, if my time has come
Thank you.
to an end. Thank you very much.
Merci beaucoup. La rapporteure pays du Zimbabwe, la commissaire Salanja, restera en contact avec nous pour ce papier que vous avez soumis et nous tenons à vous remercier. Normalement, il est midi. On est censé avoir le panel sur la peine de mort. On va prendre 3 ONG et puis on donne la place au panel. Pan-African Lawyers Union, lutte au Bebekon, numéro du statut d'observateur 485. Palou, 5 minutes. 5 minutes, please, because we have a panel.
Yes. Okay. Hello, everyone. I believe that I can be heard. If not, you can just let me know and we can try to sort it out. Okay, I proceed. Chairperson, honorable commissioners, state delegates, ladies and gentlemen, the Pan-African Lawyers Union, otherwise known as PALU, congratulates the African Commission on the successful commencement of its 79th ordinary session. We deliver the following statement on threats to the independence of the judiciary and legal profession in the African region. PALU expresses gratitude to the Commission for its resolution 570, appointing the Special Rapporteur on Human Rights, Defenders, and focal point on reprisals as the focal point on judicial independence in Africa, following PALU's intervention at the 77th Ordinary Session in Arusha. PALU notes the activities of the Special Rapporteur so far, including the advocacy statement on the protection of human rights defenders and the African Declaration on the promotion of the role of human rights defenders and their protection in Africa. We reiterate Goal 16 of the 2030 Agenda for Sustainable Development in Africa, which underscores the centrality of the rule of law in the pursuit of national development priorities. We emphasize that a legitimate democracy underpinned by the rule of law requires an active and vibrant civil society, judicial and independent oversight mechanisms, human rights defenders, as well as a free and responsible media. PALU recognizes the international, continental, and constitutional requirements of judicial independence and impartiality, and understands the crucial role that the legal profession plays in safeguarding the same. With that said, we wish to express the following regarding recent developments in select East African jurisdictions that raise grave concern for the constitutional requirement of judicial independence and impartiality, as well as the need for strong and independent bar associations. 1. In East Africa, legal professionals have been actively engaged in multifaceted advocacy strategies to promote democracy, human rights, and rule of law. Their activities are particularly significant in the current climate, where several African leaderships have created legal and logistical barriers to democracy and the rule of law. Recently, the independence of the judiciary and lawyers in the execution of their duties have been under threat in several countries in the region. We have noted several instances of sanctions taken judicially and administratively against practicing lawyers in select East African jurisdictions. Poignantly, these incidences have been applied against lawyers in the process of due and active representation of their clients and in executions of their duty to the courts. They have often been summarily imposed without due process. The independence of the legal profession in select jurisdictions is severely threatened because of the heavy influence of the executive on the code of conduct, leadership selection, and disciplinary procedures of advocates in these countries. This has facilitated a wave of arbitrary sanctions, such as suspensions against lawyers in the region. Further, against the backdrop of lack of enforcement of the judicial decisions of our national courts, there has been increased disregard of judicial orders by the executive in the last year. In addition to the culture of disregard, key officials of the executive have been found on record making inflammatory remarks that directly threaten the independence of the judiciary. This challenge is further compounded due to the high influence of the executive in the judges selection process in several jurisdictions in the region. In addition to the use of a wide range of a wide range of intimidation tactics on judges, lawyers, and human rights defenders in the region persists. In the last year, we've noticed several instances of threats, harassment, doxing, bribery attempts, and in some cases, enforced disappearances against legal practitioners. As a result of these tactics, relevant bar associations have recorded several coerced withdrawals of cases from the courts. These incidences have increasingly occurred in select East African countries in the last few months and has over time led to a pattern that, if not addressed, might threaten the independence of the judiciary, the legal profession, and the rule of law in the region. Palu thus expressed that the above accounts demonstrate a series of unfortunate outcomes that seriously undermine the capacity of the judiciary and legal profession to effectively play their role in defense of their respective constitutions, African human and people's rights standards, as well as ensuring the existence of an independent and impartial judiciary. We emphasize that there cannot be rule of law, constitutionalism, and democracy in the absence of independent and impartial judiciary supported by strong bar associations working together within the confines of the law to promote equal access to justice for all. The African Commission, through its promotional mandate, has an important role to play in the provision of guiding principles on the rule of law in Africa. At the international level, there exist several binding and non-binding instruments on the independence of justice and the integrity of the judicial system. It is time for the African Commission to adopt similar methods. Palu therefore calls on the African Commission as Special Rapporteur of the independence of judges and lawyers to, 1, develop African guidelines and standards for the independence of judiciaries and lawyers in Africa. 2, encourage the respective national government in the East African region to continue to...
Merci beaucoup. J'appelle maintenant International Lawyers Org. Are they online? 5 minutes. Et puis, il restera une dernière ONG. Les autres, ça sera pour demain pour permettre au panel d'avoir lieu. International Lawyers Org. 5 minutes.
Shukran Jazeera, Ustaz. International Lawyers appreciates the work of the African Commission. International Lawyers again draws attention to the fact that the unconstitutional changes of government are among the gravest threats to human and people's rights in Africa. The Commission should swiftly and forcefully speak out against unconstitutional changes of government wherever they occur. When the Commission delays its handling of communications concerning unconstitutional changes of government, it contributes to the problem. We encourage the African states and the Commission to support and contribute to the completion of the draft treaty on the right to development that is being prepared by the United Nations Intergovernmental Working Group. We urge all states, the Commission itself to engage in the drafting of this important United Nations treaty on the right to development. Both states and the Commission can do so by attending the sessions of the United Nations Intergovernmental Working Group on the right to development, which is meeting right now in Geneva, and making oral and written interventions encouraging a strong treaty. We welcome the efforts of the Commission to progress towards a study on the impacts of climate change on human and people's rights in Africa, which we have led civil society in encouraging since 2008. We nevertheless are very seriously concerned by the current draft that was circulated after the last public session. We have discussed this study with more than 2 dozen African states at COP28 in Dubai. None of these states found the treaty study helpful, as it is not based on the principle of common but differentiated responsibilities, nor does it recognize the importance of the principle of historical responsibility. We therefore urge the Commission to seriously rethink the study and assure that it aligns with the views of African states that are being expressed in the climate negotiations. We express our appreciation for the work of the Litigants Group, which has launched its campaign to make the Commission more transparent and effective. InternationalLawyers.org contributes to the work of the Litigants Group and fully endorses its efforts. We urge the Commission to interpret the rules so as to provide the greatest transparency possible and contribute to the effectiveness of its decisions. We also urge the Commission's increased attention for the deteriorating situation of human rights in both Sudan and South Sudan. The Commission can contribute to bringing an end to the conflict in Sudan and to helping South Sudan rebuild a stronger human rights framework for its people. We encourage the Commission to actively engage in these undertakings. Finally, we again draw the Commission's attention to the genocide that has been taking place unabated in Gaza. We welcome the efforts of African countries to end this genocide, especially the efforts of South Africa, now joined by Egypt, to challenge Israel's acts of genocide before the International Court of Justice. We regret that some African countries have failed to condemn the genocide being perpetrated by Israel and its allies. We appeal to these countries to heed the words of the Banjul Charter, which, conscious of states' duty to achieve total liberation of Africa, calls upon all African states to eliminate Zionism, the root cause of Israel's genocide. And men, women, and especially the children of Palestine are calling for your support. Thank you.
Merci beaucoup. Je vais appeler Southern Africa Litigation Center, Thabo Buthelezi, numéro statut d'observateur 420, et ce sera la dernière organisation pour aujourd'hui. Le reste, on fera demain. Buthelezi. Thabo Buthelezi, Southern Africa Litigation Center. They are online? Ils ne sont pas en ligne. Mesdames, Mesdemoiselles et Messieurs, distingués participants, chers commissaires, nous arrivons au terme de ce point sur la situation des droits de l'homme sur le continent. Il y a un autre panel qui doit prendre le relais, c'est le panel qui est conduit par le commissaire Idrissa Sow. Est-ce que le commissaire Idrissa est en ligne?
Je suis en ligne, Monsieur le Président.
Ouais, vous pouvez prendre le relais. Bonjour, bonjour de moi-même et de tous les commissaires. Prenez le relais pour ce panel-là.
Merci beaucoup, Monsieur le Président. Je voudrais saluer tous les honorables commissaires, mais aussi tous les participants à cette 79e session de la Commission africaine des droits de l'homme et des peuples. Alors, nous sommes réunis ce matin pour un panel qui porte sur la question de l'abolition de la peine de mort face aux enjeux sécuritaires. Vous savez, la question de la peine de mort fait partie des problématiques les plus préoccupantes pour la Commission africaine des droits de l'homme. À cet égard, beaucoup d'initiatives ont été prises, notamment de documents stratégiques tels que l'étude sur la peine de mort, mais également une observation générale dans laquelle la Commission a défini sa doctrine sur cette question. Aujourd'hui, le constat est que nous sommes dans une perspective, disons, positive. Positive pourquoi? Parce que sur les 55 États membres, nous avons 24 qui ont aboli la peine de mort pour toutes les infractions. Tandis que 4 autres l'ont aboli pour des infractions de droit commun. Et à côté de cela, nous notons que 15 autres États qui ont fait le choix de maintenir l'infraction, l'incrimination dans leur législation interne, observent un moratoire solide pour n'avoir pas procédé à des exécutions depuis plus d'une décennie en moyenne. Mais ce bilan reluisant ne doit pas cacher des défis. Aujourd'hui, nous rencontrons des velléités de remise en cause de ces acquis. Le seul exemple que je donnerai, c'est celui de la République démocratique du Congo, qui après plus d'une décennie sur un moratoire, a pris le contre-pied de sa doctrine sur cette question et a pris une décision consistant à remettre en cause ce moratoire. Cette problématique est assez préoccupante pour la Commission africaine des droits de l'homme. Et une communication a été élaborée et rendue publique à cet égard. Alors, l'expérience a montré que durant nos missions de promotion, les autorités avec lesquelles nous parlons nous donnent souvent une réponse qui nous inquiète. Ils nous disent souvent que oui, nous sommes conscients que pour une meilleure protection du droit à la vie, on peut aller vers l'abolition de la peine de mort. Mais les défis sécuritaires auxquels nous sommes confrontés ne nous permettent pas de le faire. Nous avons des pays qui sont en proie à des violences, à l'extrémisme violent et à des cas de rébellion. Nous ne pouvons pas, dans ces contextes difficiles, expliquer à nos opinions et leur faire comprendre une décision qui consisterait à abolir la peine de mort. Alors, l'idée d'élargir la réflexion sur cette question et de voir est-ce qu'il y a un rapport, une relation entre l'abolition de la peine de mort et les questions sécuritaires. Donc, c'est la problématique centrale de ce panel. C'est pourquoi nous avons pris l'initiative d'inviter des experts qui réfléchissent et qui s'intéressent à la question de la peine de mort pour nous entretenir de cette question. C'est l'occasion pour moi de leur réitérer mes remerciements pour avoir accepté de venir partager avec nous sur ces questions. Donc, autour de cette question aujourd'hui, nous entendons Madame Anna Céleste Januario, qui, comme vous le savez, est secrétaire d'État aux droits de l'homme de la République d'Angola. Elle est juriste spécialiste des droits de l'homme et membre d'une équipe de recherche de l'Université de Buenos Aires en Argentine. Madame John est auteure de plusieurs articles et publications scientifiques. Nous avons également, pour discuter de cette question, Madame Zeynab Kaïdissi, que nous connaissons à la Commission, puisqu'elle a été présidente de la Commission africaine des droits de l'homme, mais également commissaire en charge du groupe de travail sur l'abolition de la peine de mort. Madame Sylvie Kaïdissi est juriste, diplômée de droit pénal international et spécialiste de questions de droits de l'homme. Elle est ancienne présidente de la Cour suprême de son pays, le Rwanda, et occupe actuellement le poste de directeur des affaires juridiques de la communauté économique des États de l'Afrique centrale, CEAC. À côté de ces éminents spécialistes, nous avons le docteur Ndolovu. Docteur Ndolovu est expert de notre travail. Il est professeur de droit à l'école de droit de Mandela en Afrique du Sud. Il est juriste reconnu et auteur de plusieurs publications scientifiques. Nous aurons également Michel Kalemba, qui nous parlera de la perspective en Afrique centrale, la perspective de l'abolition de la peine de mort. Michel Kalemba est membre de la FIACAT qui est un partenaire stratégique de notre groupe de travail et qui travaille beaucoup sur les questions de l'abolition de la peine de mort. Donc, sans plus tarder dans l'intérêt du temps, je vais commencer par donner la parole au docteur Ndolovu pour 10 minutes. Chaque intervenant aura 10 minutes. À l'issue de ces interventions, je passerai le relais à l'honorable Maria Teresa Manuela pour recueillir les observations et éventuellement des questions des participants pendant 25 minutes. À l'issue de ce round de questions-réponses, nous donnerons la parole aux exposants pour leurs propos conclusifs. Donc, sans plus tarder, M. Ndolovu, je vous passe la parole pour nous donner votre perspective sur cette question que nous débattons, c'est-à-dire sur les enjeux de l'abolition face aux défis sécuritaires. Vous avez la parole.
Thank you so much, Honorable Commissioner Idrissa Sow. Greetings to Your Excellencies, greetings to the Chair, ladies and gentlemen. We here discussing a very important issue, that the Commission is so involved with, particularly the abolition of the death penalty in Africa. And as the Commissioner so, correctly puts it, that quite a lot of work has been put, perhaps by the Commission in terms of an approach to an abolitionist approach in protection of the right to life. In addition, protection of the right to not to be subjected to torture, inhuman and degrading punishment. So my intervention is in relation to the link or the nexus between the death penalty and human security or public security. And I want to put it on record to say, as it stands, we don't have conclusive proof from studies and from scholarship and from discussions as to whether indeed the death penalty does deter criminality or does ensure perhaps safety in society. Because even in countries where the death penalty is still active, and in countries where the death penalty is not active or there's a moratorium, both in the continent and beyond, we still have commission of crimes as a result of many valid reasons. So it is not yet conclusively proven. And my focus is going to be largely on Southern Africa, but I may perhaps refer to a country or two or jurisdiction outside Southern Africa, as Commissioner so did with reference to DRC. Now, for the longest time, the southern part of the continent sort of adopted a different approach. I think initially, very early years of independence, most countries retained the death penalty in their statute books. But as time went by, we see sort of a deviation of approach from a retentionist approach to an abolitionist approach. Countries such as South Africa and Namibia, the youngest to be born, to put it that way, in the southern part of the continent, sort of very first in their constitutional and legislative provisions, putting in place measures to ensure the abolition of the death penalty. And of course, we see also the development and progression with the latest developments in Zimbabwe, in particular, the move by cabinet to approve the abolition bill, which if it sees the light of the day in parliament, I don't see it having difficulties passing through the office of the president, in particular because of his approach to the issue. He is abolitionist in nature, he has said it publicly, and we recommend him for that. Now, when it comes to human security and the death penalty, maybe the question that we should ask ourselves is it indeed true as to whether the death penalty does indeed perhaps deter crime or perhaps reduce criminal activity? And the answer to it, I'll say it depends. But from my own perspective, the question should start with what are the causes of criminality in our society? Because starting with the death penalty is at the end of the spectrum and is a reactionary approach to criminality. Yet we do not deal with the issues, the root causes of crime. In particular, we do have structural issues such as poverty, socioeconomic inequality, unequal distribution of resources, lack of moral support in society, or broken ethical morals, etc., that lead to, especially the young ones or the youth, being involved in criminality with aggravating circumstances, which in some jurisdictions then invite, if a person is convicted, a death penalty sentence. Now, once that sentence is passed, the question remains, is it going to deter others from committing the same or even worse? The answer to it, let's deal with the issues that underlie criminality than imposing the death penalty, because the death penalty, as I said earlier in my submission, is reactionary in nature and does not necessarily solve our structural issues that lead to the commission of crime. So what we need to deal with is to try and focus and see what is it that makes people commit crimes? Is it poverty? Are there any means that are channeled to deal with that? I mean, if you go to our SDGs, etc., I think all African countries currently, including those in Southern Africa, sort of put in measures in place to ensure that they eradicate hunger, they eradicate poverty, they ensure access to school and education. These are some of the interventions that we must speak with, because they deal with the foundations and the roots of criminality, that at the end, you have states reacting with the sanction of a death penalty, which does not necessarily deal with the underlying structural issues that we face. And as a result, you also have issues of religion and culture that might influence some jurisdictions and public opinion as to whether or not we should retain the death penalty. But the submission, therefore, is that in terms of the obligations that emanate from the African Charter, states, therefore, should put in place measures and mechanisms that ensure that the right to life, which is a sacred right, and I think it has been argued from by different scholars, that this is one of the supreme rights in which, if we do not have it, all other rights are devoid of meaning. We do not have, perhaps they do not matter once life is taken away. Now, and therefore we should be prioritized in accordance and in line with the obligations of that emanate from the African Charter. And as I said earlier, there are certain developments from the African states in this particular, part of the continent, both progressive and retrogressive. I'm going to refer to one or two. In terms of progression, we see developments that have sort of taken place recently, like, as I said, I think in the last 2-3 months in Zimbabwe, in particular, the passing or the approval rather of the abolition bill by the cabinet, in that state. Things being equal, we should be seeing perhaps or encouraging, Parliament in that jurisdiction to sort of move swiftly to approve the bill and perhaps send it for presidential assent. This comes after wide discussion with the, perhaps if you look in terms of the notes of that approval, discussions, public opinion in terms of whether or not is death penalty still, perhaps acceptable in our modern society, especially because of the obligations emanating from the African Charter, the African Children's Charter, and the Maputo Protocol. And the answer to it from the discussions that we see in that jurisdiction is that the death penalty is unacceptable because it takes away a sacred right, the right to life, and of course the right not to be subjected to inhumane and degrading punishment. And putting it together with what scholars have put forward is that it does not necessarily solve us to deter crime, but in essence, it makes us to sort of deviate from obligations in terms of what is provided for in the Charter. Now, this does not necessarily mean that life cannot be taken, and I must put this on record to say, in instance of self-defense and necessity, perhaps there may be loss of life, which we do not perhaps expect sometimes from the state or from individuals, and we cannot, there's no justification that can be put forward that the death penalty either form part of necessity or private defense. It cannot be. Our understanding is that the death penalty is an affront to the right to life and cannot be justified using private defense or necessity under any law. Now, again, I refer to some of the jurisdictions that we see progress. And again, such as Madagascar, Mauritius, Mozambique, Namibia, Seychelles, South Africa, and Zambia. And of course, some sort of positive aspects from Malawi. Now, taking it back to the question at hand as to whether there's a nexus between crime and human security or public security. I think from the submission that I've so far made is that if we check the crime stats in all these jurisdictions, there seem to be similarity or, in terms of either the development of the country, the economy of the country, etc., that go just beyond, perhaps using death penalty to detect commission of crime with aggravating circumstances, but goes to the structural issues that I referred to earlier to say the energy should be channeled towards dealing with the structural issues that sort of erode away perhaps humanity, the issues that lead to individuals committing crime. Those should be where the energy should be channeled, not necessarily using a reactionary approach which is not necessarily not aligned to justice theory, if we can put it that way. And some of the perhaps recommendations as I move towards conclusion, Chair, include some of the dangers that we continue to see, especially because of the human error, where judges might, in certain circumstances, find a person guilty and therefore sentence that person or individual to a death penalty, and later on it is discovered that it was not the person that committed the crime, yet maybe there's an execution that has taken place now. How do we reverse that? Those are some of the ethical dilemmas that are associated with using the death penalty, or that remains in some of our statute books. And also that it is torture, inhumane and degrading punishment, as was held in State versus Makwanyane in South Africa, and Kindler v. Canada in a dissenting view in the European ICCPR periodic review. Now, again, where are we in terms of poverty reduction? Where are we in terms of access to education that deal away with issues or take away people from the streets or from this criminal mentality? So we need then to take stock in terms of the development that is taking place in our jurisdiction, in particular as to whether or not there is progress. Because if there's that progress, we check stats as to whether or not is crime perhaps perhaps is it increasing, is it decreasing? What are the stats? Where are we? We move towards advocacy also and awareness and talk to persons and see, especially, or learn from countries in Europe, for instance, where the death penalty has almost been abolished in most of them. What measures have they put in place to ensure that perhaps there's less commission of crime? And in other words, as to whether there is nexus between the death penalty, and of course the human security. Because my conclusion from research, what we see is that the more states are developed and the more economic development takes place and the more people have access to education, we see a sharp decrease in crime. We see a sharp decrease in people, entering into drug use and all these other activities that lead to the commission of crime, which then activates death penalty in states where it is still active. So we need to go back to ground zero, check our structural issues, where are we and where do we want to go? And we see again progressive development in one of the jurisdictions, Ghana, recently as well, in terms of moving towards the abolitionist approach. And I think we recommend that jurisdiction in terms of dealing with the death penalty, heads on, and of course the commitment from the highest levels to ensure that no one is executed, etc. And as I move towards conclusion, we need to ensure, Chair, that the obligations as per the African Charter are abided to by states, and the state reporting mechanisms that are put in place should show, perhaps progression towards a complete abolition of the death penalty. And things being equal, that we should see, at least in the light of the day, of course, the protocol that perhaps is on the table, and possibly that states are going to ratify it, and we see good progress in that regard. But as it stands, there's no clear direction as to whether there is really perhaps help that we get in society from using the death penalty as a deterrent and using the death penalty to deal with human security. What we need to deal with are the structural issues that society must face heads on, in line with our SDGs, and of course in line with our African Charter obligations. Thank you so much. Merci beaucoup.
Merci beaucoup, Dr. Nkogu, pour cette conclusion intéressante. Dans votre perspective, vous avez montré que les causes profondes de la criminalité doivent plutôt être cherchées dans les fondements économiques et sociaux, dans les inégalités sociales, dans les questions de sous-emploi, dans les questions d'accès aux ressources de base dans la société. Cette perspective est intéressante. Je vais maintenant donner la parole à Mme Anna Sanchez-Mario pour qu'elle nous évoque sa vision sur cette question, en partageant avec nous l'expérience angolaise sur l'abolition de la peine de mort, qui, comme vous le savez tous, a été opérée dans un contexte de conflit armé. Excellence, vous avez la parole.
Muito obrigada. Primeiro, thank you. Monsieur Idrissa Sow, honorável comissário. Je ne sais pas si c'est possible se me ouvem. Conseguem ouvir-me?
Oui, nous vous entendons très bien.
Ah, oui, merci. Honorável presidente deste painel, comissário Idrissa Sow, e também presidente do grupo de trabalho sobre a pena de morte, honorável comissária Manuela, comissária Caetese, o senhor Ido, nosso painelista, minhas senhoras e meus senhores. É com imensa honra que aceitamos o convite para partilhar este painel com especialistas em direitos humanos e sobretudo, para falar sobre a questão da pena de morte. A pena de morte, pena capital, homicídio judicial, é um atentado ao direito à vida, há uns princípios fundamentais do ordenamento jurídico e dos direitos humanos. E como já vimos aqui, em muitos países africanos...
Pardon, madame,
Oui.
nous avons des problèmes. Voilà, c'est bon maintenant, nous avons l'interprétation en français. Vous pouvez continuer.
A pena de morte, a pena capital, o homicídio judicial é um atentado ao direito à vida enquanto dos princípios fundamentais. E como já foi referenciado aqui, em África, 3/4 dos nossos países são abolicionistas. Pensamos que isso tem muito a ver com os princípios, as filosofias ancestrais africanas, de proteção à vida, a nossa capacidade de diálogo e confluência de culturas. O uso da pena de morte enquanto execução com sentença imposta por um tribunal a um prisioneiro deve ser considerado quando nós trabalhamos em direitos humanos. Em Angola, nós aprendemos isso de um ponto de vista muito prático. Nós ficamos independentes em 1975, a nossa independência, como a de muitos países africanos, foi conquistada através de conflito. E num conflito tem mortes. No pós-independência tivemos também um longo período de guerra, que durou até 2002. Conto isso porque, como vocês podem ver a nossa história de país abolicionista começou mesmo no período em que nós estávamos de guerra. A pena capital foi abolida formalmente em 1991, na revisão constitucional, mas tinha deixado de ser aplicada em 1979. A primeira Constituição de Angola, a Constituição 175, não estabelecia a pena de morte. Ela estabelecia no seu artigo 17 a proteção da vida e da dignidade da pessoa humana. Entretanto, uma lei adicional, a Lei 378, ela veio estabelecer a pena de morte. O Código Penal que vigorou no início do nascimento da República de Angola, que é o Código Penal de 1886, deixado pelos portugueses, também já estabelecia a pena de morte. Entretanto, tal como eu já disse, em 1979, Angola deixou de aplicar a pena de morte e, através da Lei Constitucional 2392, no seu artigo 22, proibiu-se então formalmente a pena de morte. A Constituição atual, que é de 2010, ela segue o mesmo espírito da Constituição de 92 e vem estabelecer um artigo 30, proteção da vida, e um artigo 59, a proibição da pena de morte. Na mesma linha, o Código Penal angolano, que é de 2020, também proíbe os crimes de homicídio simples e homicídio qualificado. E também vem referido às principais causas de ilicitude, estados de necessidade, legítima defesa, consentimento do ofendido, etc. Relativamente aos nossos compromissos internacionais e regionais, Angola é parte da Carta Africana dos Direitos Humanos e dos Povos, de 1986, a nossa Carta de Banjul. Angola é membro desde 1990 e a Carta, apesar de nas suas disposições não trazer nenhum artigo relativo à pena de morte, mas o nosso Tribunal Africano dos Direitos Humanos e dos Povos refere-se nos artigos 5º e 6 e também através de vários acórdãos Ali Rabajo versus Tanzânia ou Saif Gaddafi versus Líbia, esta questão da proteção da vida. Em 92, Angola aderiu ao Pacto dos Direitos Civis e Políticos, assinou em 2013 e aderiu em 2009 o protocolo relativo à pena de morte. Em termos institucionais, nós temos os tribunais de primeira instância. Neste momento, temos 37 tribunais de comarca, temos 3 tribunais da relação, da Huila, Benguela e Luanda, e temos o Tribunal Supremo. A par disso, funciona também entre nós o Tribunal Constitucional, um tribunal a quem compete administrar a justiça em matéria jurídico-constitucional. Os nossos tribunais não aplicam a pena de morte, como já referi, desde 1979, mas temos desafios ligados à justiça por mãos próprias e também a casos de execução extrajudicial. Tanto um caso como o outro são todos considerados crimes na nossa legislação e sancionados os seus agentes. Temos jurisprudência, muita jurisprudência, em que há julgamentos e responsabilização dos agentes, sobretudo agentes de Força de Defesa e Segurança, envolvidos em casos de execução extrajudicial e também de cidadãos. Agora, em fevereiro de 2024, tivemos uma situação que chamou e provocou a comoção do cidadão, que é um músico de gospel, que se chama Caleb Zinga, que aqui em Luanda, no bairro Kazenga, foi acusado de ter furtado, e com isso a população acabou por agredi-lo, provocando a morte do Caleb. Esta morte do Caleb, injusta, provocou a indignação social e com isso temos então a espera do julgamento e nos pôs mais uma vez a refletir sobre que medidas devemos tomar para esse tipo de execuções que podemos chamar penas de morte na prática, que é um bocadinho prática em muitos contextos da África, não é? Em que o cidadão usa do seu poder e acaba tirando a vida de outros. Temos também boas práticas. Angola é membro da Coligação contra a Tortura Internacional, somos membros da Coligação para a Abolição da Pena de Morte, e inclusive a nível da CPLP, que é a comunidade dos países que falam português, Angola, durante a sua presidência, impulsionou que a Guiné Equatorial usasse a sua cláusula de suspensão. E o presidente Lourenço, enquanto presidente da CPLP, estimulou e trabalhou para que a Guiné Equatorial pudesse fazer o caminho para a abolição formal da pena de morte. Também a nível da Assembleia Geral das Nações Unidas, desde 2007 que Angola tem estado a votar contra a favor das resoluções sobre a moratória para a pena de morte, e estas posições têm estado a tomar em 2010 e a última em 2020. Entretanto, enquanto país nesse continente africano, estamos preocupados com os sinais da aplicação da pena de morte por alguns países que já tinham aderido à moratória, mesmo que seja aplicada a crimes militares, é de facto um desafio e uma preocupação. Por isso apelamos a que não haja retrocesso de nenhum país, como também de casos de aplicação da pena de morte na prática, que penso ser um desafio maior para todos os países africanos. O empenho e o compromisso de todos é muito importante. Esta, minhas senhoras e meus senhores, é a experiência de Angola, que como desafio referi acima, vamos preservar a vida. E por isso somos a favor da moratória e também da adoção de um protocolo africano relativo à pena de morte. Muito obrigada.
Je remercie Madame Januario. La clarté de votre exposé, en fait, me dispense de faire un résumé. Je retiendrai simplement pour l'essentiel que vous avez montré à travers l'exemple angolais. Il était possible d'aller vers l'abolition, même dans un contexte de conflit armé, puisque vous avez montré que c'est à partir des années 79 que le mouvement abolitionniste a pris naissance dans notre pays, et le processus a été poursuivi jusqu'à ce que ça aboutisse à une loi abolissant la peine de mort de façon totale. Mais vous avez aussi pointé du doigt un aspect important, c'est qu'à chaque fois qu'il y a dans nos pays des crimes violents qui ont ému l'opinion, nous assistons à des résurgences, des velléités de demandes tendant à ce que les autorités à restaurer la peine de mort. Mais ces questions également de mon point de vue doivent être gérées avec tact dans nos pays, dans le pays. Cette perspective est intéressante. Je voudrais maintenant passer la parole à Madame Zaid pour qu'elle nous parle des enjeux de l'abolition de la peine de mort en Afrique centrale. Madame Keititi, vous avez la parole.
Merci, honorable commissaire, honorable président de la commission, honorable commissaire, distingués participants à ce panel. Bonjour. Mes hommages aux anciens collègues commissaires et membres de la société civile avec qui nous avons travaillé pour la cause de l'abolition de la peine de mort. J'ai été saisie pour faire une présentation sur les enjeux de l'abolition de la peine de mort en Afrique centrale. Oui, en Afrique centrale, qui est constituée de 11 États, et là je me réfère à la communauté économique des États de l'Afrique centrale, qui regroupe 11 États, c'est-à-dire la CEEAC. Et ces 11 États sont l'Angola, le Burundi, le Cameroun, la Centrafrique, le Congo, la RDC, le Gabon, la Guinée équatoriale, le Rwanda, Sao Tomé et Principe et le Tchad. Donc, ma présentation va focaliser essentiellement sur l'enjeu de l'abolition de la peine de mort dans ces 11 États. Elle consistera à faire une évaluation de l'état de l'abolition de la peine de mort au sein de ces États, membres de la CEEAC, de l'état de ratification du second protocole se rapportant au pacte international relatif aux droits civils et politiques visant à abolir la peine de mort, de la tendance dégagée par le vote de la résolution biannuelle de l'Assemblée générale des Nations unies portant sur un moratoire sur l'application de la peine de mort et de la pertinence et de l'adoption du protocole additionnel à la Charte africaine des droits de l'homme et des peuples portant sur l'abolition de la peine de mort en Afrique. S'agissant de l'état de l'abolition de la peine de mort dans les États membres de la CEEAC, nous avons 9 États sur 11 qui ont aboli la peine de mort. Il s'agit de l'Angola, le Burundi, le Congo, le Gabon, la République centrafricaine, le Rwanda, le Sao Tomé et Principe et le Tchad pour tous les crimes et la Guinée équatoriale pour les crimes de droit commun. Le Cameroun observe un moratoire sur les exécutions depuis 1997. La RDC a récemment levé le moratoire sur la peine de mort en place depuis 2003 lors de la 124e réunion ordinaire du Conseil des ministres du 9 février 2024. Et cette volonté de reprendre les exécutions a été officialisée par un circulaire du 13 mars 2024 du ministre de la Justice. Alors, ici, de constater que parfois, la peine de mort aurait été considérée comme ayant un effet dissuasif pour le maintien de la sécurité, que ce soit face au banditisme, au terrorisme ou dans les cas de conflits armés. Mais toutefois, cet effet dissuasif n'a jamais été démontré. Au contraire, il relève de la rhétorique. Certains pays qui font face aux conflits armés, à l'instar du Tchad, de la Centrafrique, ont aboli la peine de mort, tandis que d'autres, en proie au conflit armé, la maintiennent dans la législation, notamment le Cameroun, qui observe le moratoire. La RDC a toujours observé le moratoire depuis 2003, sauf qu'il a été récemment levé. Observant un moratoire sur les exécutions depuis 1997, le Cameroun a fait recours à la peine de mort en 2014 dans le cadre de la lutte contre le terrorisme, avec un élargissement du champ des infractions passibles de peine de mort et une explosion des condamnations à mort. Et depuis 3 années, l'ouverture du débat national sur l'abolition de la peine de mort a entraîné une chute du nombre de condamnations à mort. Et en 2021, le Cameroun avait prononcé 4 condamnations contre 0 en 2022. S'agissant d'adhésion au 2e protocole facultatif se rapportant au pacte international relatif aux droits civils et politiques visant à abolir la peine de mort, seuls l'Angola, le Gabon, le Rwanda et la Sao Tomé et Principe ont adhéré au dit protocole, qui est un seul traité international qui interdise la peine de mort. Il faut constater que le faible taux de ratification de cet instrument traduit une large réticence des États à être liés par un traité dont la dénonciation produit ses effets après une certaine période. Et on peut présumer que les États veulent conserver le droit de réintroduire la peine de mort avec effet immédiat, soit en modifiant la législation nationale, soit en levant le moratoire, comme ça a été le cas pour la RDC. Maintenant, s'agissant de la résolution des Nations Unies pour un moratoire universel, depuis 2007, l'Assemblée générale des Nations Unies vote tous les 2 ans une résolution pour un moratoire universel sur l'abolition de la peine de mort. Et le 15 décembre 2022, l'Assemblée générale des Nations Unies, comme d'habitude, a adopté la 9e résolution pour un moratoire sur l'application de la peine de mort, avec 125 voix en faveur, 2 plus qu'en 2020, et 37 voix contre, 22 abstentions et 9 absents. En 2022, les pays membres de la CEAC ont voté comme suit. Le vote est pour. Il y avait l'Angola, Congo, République centrafricaine, Guinée équatoriale, le Rwanda et le Tchad. Absent, il y avait la Sao Tomé et Principe. Et abstention, il y avait le Burundi, Cameroun et Gabon. Voter contre RDC pour la première fois. Le constat est que le vote positif exprimé par l'Angola, le Congo, la Centrafrique, la Guinée équatoriale, le Rwanda et le Tchad réaffirme l'engagement ferme de ces États à l'abolition de la peine de mort dans leur pays. Et l'abstention du Burundi, du Gabon, était surprenante dans la mesure où les deux États ont aboli la peine de mort pour tous les crimes en ce qui concerne le Burundi et les crimes de droit commun en ce qui concerne le Gabon. La RDC a voté pour la première fois contre la résolution. Et on peut dire, a posteriori, que ce vote présageait la levée du moratoire adopté en février 2024. L'abstention du Cameroun soulève des interrogations dans la mesure où le pays observait déjà un moratoire sur la peine de mort. Donc, il y a lieu de constater un certain frein, voire un recul dans la dynamique de l'abolition de la peine de mort en Afrique centrale. Et en fait, s'agissant de la pertinence du protocole à la Charte africaine des droits de l'homme et des peuples portant abolition de la peine de mort en Afrique, eu égard aux réticences déjà mentionnées, faut-il tout de même espérer un soutien des États au projet de ce protocole? À mon avis, la réponse est positive. En dépit de quelques reculs notés, la dynamique mondiale abolitionniste se poursuit, ce qui nourrit l'espoir que les réticences seront vaincues progressivement. Et je pense qu'en conclusion, nous pouvons dire que quelles que soient les raisons de la réticence des États, la peine de mort ne peut constituer une réponse efficace aux problèmes de sécurité. S'il est vrai que tout individu a peur de la mort, il n'existe aucune preuve que la peine de la mort soit plus dissuasive que les autres châtiments, dont la peine à perpétuité. Parallèlement, de nombreuses familles de victimes affirment que la peine de mort ne permet pas réellement de soulager leur souffrance et ne fait que tendre la souffrance de la famille, de la victime, à celle du condamné ou de la condamnée. Bref, la peine de mort ne protège personne. Ainsi, j'appelle à la Commission africaine et aux autres parties prenantes à poursuivre les efforts pour le plaidoyer et l'explication aux États réticents sur le bien fondé de l'abolition de la peine de mort, quels que soient les contextes sécuritaires, pour l'adoption du protocole additionnel à la Charte africaine sur les droits de l'homme et des peuples, afin de disposer d'un instrument juridique au niveau continental et pour le vote de la résolution biennale des Nations Unies pour un moratoire universel. Au fait, en ce qui concerne ce projet de protocole additionnel à la Charte africaine, un travail énorme avait été déjà fait et je pense que la Commission africaine poursuit ses efforts en ce sens. Au niveau du plaidoyer, on était déjà avancé et lorsque j'étais la présidente du groupe de travail pour l'abolition de la peine de mort en Afrique, ce projet avait franchi des étapes satisfaisantes. C'était à un niveau satisfaisant. Vous vous rappelez ceux qui étaient là. Le texte a été présenté jusqu'au niveau des instances décisionnelles. Mais pour des raisons que vous ne pouvez pas ignorer tous, le projet a été arrêté à un certain niveau, mais nous pensons que nous ne devrions pas croiser les bras. Il faut continuer, il faut lutter toujours, et un jour, on pourra arriver à cet instrument au niveau de notre continent. Et
Merci
je
beaucoup.
pense qu'en peu de mots, Monsieur le Président de la séance, c'est ça que je voulais vous communiquer en ce qui concerne le sujet qui m'a été confié. Et je vous remercie.
C'est moi qui vous remercie, honorable Kaïtissi, d'avoir bien voulu partager votre perspective sur une question que vous connaissez très bien, pour avoir présidé le groupe de travail sur la peine de mort. Votre intervention est très riche en informations sur la situation de la peine de mort en Afrique centrale. Vous avez donné des statistiques en montrant que 9 États ont aboli sur 11. Vous avez aussi relaté le comportement des États de l'Afrique centrale face au vote du moratoire au niveau de l'Assemblée des Nations Unies. Mais le plus important, de mon point de vue, c'est que vous avez montré qu'il n'y a pas une relation établie entre le maintien de la peine de mort et l'augmentation de la criminalité. Vous avez observé qu'il n'est pas établi que dans les États qui ont fait le choix de garder la peine de mort dans leur législation, que la criminalité a baissé. Et dans l'autre sens également, vous avez fait observer que dans les États où la peine de mort a été abolie, il n'a pas été prouvé. On a assisté à une montée en flèche de la criminalité. Cette perspective est... Alors, nous avons vu qu'aujourd'hui, il y a des velléités de remise en cause des acquis dans le mouvement abolitionniste en Afrique. Il y a des moratoires qui sont en train de sauter. Et il y a une certaine réaction qui a aujourd'hui de se développer, notamment avec les organisations de la société civile. J'ai été particulièrement intéressé ce matin lorsque que notre commission, le statut d'observateur à la coalition tunisienne contre la peine de mort. Et dans l'argumentaire qui a été présenté à la commission, il a été fait mention de cette velléité de retour à la peine de mort dans ce pays. Donc, il y a nécessité de sécuriser les acquis dans le processus de l'abolition de la peine de mort en Afrique. C'est sur cette question que nous voulons entendre Michel Kaleba, qui est, comme je l'ai dit, membre du Bureau international de la FIACAD. Selon vous, quelle est l'importance de la sécurisation de cette abolition face au risque de résurgence de la peine de mort en Afrique? Vous avez la parole pour nous, M. Kaleba. M. Kaleba, vous avez la parole pour 10 minutes.
Vous m'entendez? Je ne sais pas si vous parvenez à m'entendre directement.
Nous entendons.
Vous m'entendez?
Oui, nous vous entendons. Je vous ai donné la parole pour 10 minutes.
Merci de m'avoir accordé la parole. Il m'a été demandé de pouvoir dire un mot sur l'abolition de la peine de mort face au risque de résurgence cas de la République démocratique du Congo. Malgré les recommandations nombreuses faites à la République démocratique du Congo en vue de l'abolition de la peine de mort, mais celle-ci tarde toujours à donner effet aux recommandations qui lui sont faites. Elle a voulu demeurer sous le régime du moratoire qui a duré plus de 20 ans et qui vient d'être révoqué pour les raisons que nous allons voir un peu plus loin. Je vais, à travers mon propos, essayer d'aborder 4 points, notamment faire un état des lieux sur la peine de mort en République démocratique du Congo, parler des engagements de la République démocratique du Congo en ce qui concerne le moratoire qu'elle vient de révoquer, parler également de la reprise des exécutions après ce moratoire de 20 ans et enfin chuter sur la sécurisation de l'abolition de la peine de mort. En ce qui concerne l'état de lieu de la peine de mort en République démocratique du Congo, l'éventail des infractions qui sont passibles de la peine de mort en République démocratique du Congo est très large. La peine de mort peut être encourue aujourd'hui pour près de 100 infractions. La majorité de ces crimes sont prévus par le code pénal militaire. Dans ce code, 74 crimes sont passibles de la peine de mort, y compris des crimes qui ne comportent aucun élément intentionnel tel que la lâcheté, la captivité devant l'ennemi, la détention de la drogue ou le refus d'obéir aux ordres du supérieur en temps de guerre. Alors, quant au code pénal ordinaire, celui-ci prévoit la peine capitale pour 19 infractions, dont le vol à main armée ou l'espionnage. Alors, le nombre d'infractions qui sont passibles de la peine de mort en République démocratique du Congo ne répondent pas aux critères des crimes les plus graves et de nombreux civils sont condamnés par les juridictions militaires, ce qui est contraire aux préconisations de la Commission africaine des droits de l'homme et du peuple faites dans son observation générale sur le droit à la vie. Selon la législation congolaise, plusieurs catégories de personnes sont exclues de la peine capitale. Théoriquement, les enfants ne peuvent pas aujourd'hui être condamnés à mort. Ils ne peuvent être jugés par la justice militaire. Ils ne peuvent pas être condamnés à mort par la justice civile. Alors, la législation congolaise ne contient aucune disposition spécifique concernant l'imposition de la peine de mort aux ressortissants étrangers. La peine de mort est applicable que l'accusé soit congolais ou étranger. Donc, il existe 2 modes d'exécution de la peine de mort. La pendaison pour les civils, la fusillade pour les militaires. La loi dispose par ailleurs que les exécutions sont publiques et que les personnes condamnées peuvent être assistées d'un ministre de culte le jour de leur exécution. Au niveau international, la RDC s'est constamment abstenue ou absentée lors de votes des résolutions appelant à un moratoire sur l'application de la peine de mort par l'Assemblée générale des Nations unies, alors même qu'elle s'est engagée par le passé à voter en faveur de ces résolutions. On a à un moment donné pensé par la ratification en mars 2002 de statut sur la Cour pénale internationale que la RDC allait enfin amener le législateur national à clarifier définitivement cette situation en s'alignant sur la philosophie abolitionniste du droit international pénal. une proposition de loi portant abrogation de la peine de mort a été présentée au Parlement par les députés André Mbata et Nyabirungu et déposée. Elle sera cependant rejetée par le Parlement congolais en novembre 2010 au terme d'un débat général d'une rare violence verbale. En 2015, le Parlement congolais adopte de loi de mise en œuvre du statut de Rome qui inclut la peine de mort, alors que, en regardant l'échelle des sanctions dans le statut de la Cour pénale internationale, la peine de mort n'y figure pas. Le 21 août 2019, à l'occasion de la session ordinaire de l'Assemblée nationale, l'honorable André Mbata introduit à nouveau une nouvelle proposition de loi visant l'abolition de la peine de mort et qui a été envoyée au bureau d'études de l'Assemblée nationale afin de l'examiner. Et à ce jour, cette proposition de loi émanant de l'honorable André Mbata n'a pas toujours été examiné par le Parlement et il moisit dans les tiroirs de l'Assemblée nationale. En octobre 2019, le vice-ministre de la Justice avait annoncé la commutation de toutes les condamnations à mort ainsi que l'abandon de la peine de mort dans le projet du nouveau code qui, à ce jour, n'a pas encore été soumis au Parlement. Ça, c'est du point de vue de cet état des lieux, les tentatives qui sont menées au niveau national par les élus du peuple vouées à l'échec. Alors, qu'en est-il de l'engagement de la République démocratique du Congo à pouvoir instituer le moratoire? La République démocratique du Congo a institué le moratoire et que ce moratoire, qui vient à peine d'être révoqué par les autorités congolaises, était justement en train de freiner l'application des exécutions capitales et que cela relevait des engagements pris par les autorités congolaises à l'époque. Et ce moratoire qui a été institué par les autorités congolaises, c'est un moratoire de facto, pas un moratoire légal, qui est une situation très fragile, comme vous allez le constater, et qui permet à ce jour à l'État congolais de pouvoir les révoquer et de recommencer les exécutions capitales. L'expérience en Afrique a montré que le moratoire n'est pas une garantie absolue contre les exécutions ou pour une abolition future. Les régimes de l'arbitraire, l'avènement de gouvernements populistes, la prolifération de coups d'État militaires et l'émergence de nouveaux défis sécuritaires poussent certains États autocratiques ou militaires à reprendre les exécutions sans aucun scrupule, même après un moratoire d'un quart de siècle. C'est comme le cas de la République démocratique du Congo qui a bien évidemment observé ce moratoire de plus de 20 ans et à ce jour, ce moratoire est révoqué. Alors, en révoquant ce moratoire, la République démocratique du Congo se fonde sur les violences qui sont commises dans sa partie orientale, là où
Nous n'entendons plus M. Kalemba. Peut-être qu'il a un défi avec Internet. Ce qu'il a dit est intéressant. Il a fait des infractions sont punies de la peine de mort dans son pays, la RDC. Il a fait des choses sur le régime juridique, la peine de mort dans son pays, et montrer, de mon point de vue le plus intéressant, la fragilité des moratoires qui sont actuellement
Vous allez
appliqués dans nos
m'excuser,
pays.
à Kinshasa, il pleut abondamment. C'est la raison
Oui.
d'être de la coupure
Monsieur Kaleba, vous
Internet.
avez 2 minutes pour conclure.
Vous l'avez
2 minutes, s'il vous plaît. Je suis en train de résumer ce que vous disiez. Vous avez 2 minutes pour conclure.
remarqué. Alors, qui du reste est très fragile et représente le moratoire sur les exécutions, il est important de sécuriser les
Je suis vraiment désolé, mais nous sommes obligés peut-être de mettre fin à cette intervention, compte tenu des défis techniques. Mais le plus important, c'est que son message est passé. Il a montré la précarité dans laquelle se trouvaient les moratoires en Afrique. Mais il a également pointé la nécessité de déployer des stratégies pour sécuriser ces moratoires-là. Et je crois que c'était ce qui était attendu dans son intervention. Je voudrais maintenant conclure le cycle des présentations en remerciant une fois les communicants. Nous allons maintenant ouvrir une série de questions-réponses et recueillir éventuellement des observations et des contributions de la part de ceux qui assistent. À ce stade, je voudrais passer le relais à mon collègue l'honorable Maria Teresa, vice-présidente de notre groupe de travail, pour conduire les débats. Madame Manuela, vous avez la parole.
Obrigada, senhor presidente do Grupo de Trabalho. Muito boa tarde a todas e todos, caros colegas, sendo hoje a primeira oportunidade que eu tenho de falar. Cumprimento a todos e a cada um, de acordo com o protocolo. Espero que já haja interpretação. Temos interpretação? Sim, senhora. Então, tendo terminado os nossos 4 painelistas de colocar-nos ao corrente do que se pensa em relação à pena de morte e as 2 experiências trazidas, uma de Angola e outra da República Democrática do Congo, passemos agora para a fase de perguntas e respostas, contribuições. Portanto, passo a palavra a quem quiser tê-la e, para o efeito, deve apenas levantar, fazer o sinal de que vai intervir e passaremos imediatamente a palavra. Começo pelos que estão online, depois faremos a distribuição de palavra pelos que estão na sala. Não há comentários? Contribuições? Ok. 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 Então, tenho aqui uma lista dos intervenientes para este bloco. Começo por passar a palavra ao senhor Felizmino Lisboa, portanto, do Ministério da Justiça e Direitos Humanos de Angola, membro, portanto, de um Estado. Tem a palavra, senhor Felizmino, está em linha? Aituel? Não? Não? Temos instituições nacionais de direitos humanos. A senhora Bamba Koná Joel. Se estiver em linha. Também não. Da República Democrática do Congo. Temos o senhor Roberto Akoto Amoafo. Também não. Passemos para as instituições, para as organizações não governamentais. Temos 2 inscrições. Senhor Nadim Mulai. E o senhor ou a senhora Shabani Ariel, também da República Democrática do Congo. Para além destas inscrições, aqui na sala, senhores comissários, alguém quer contribuir, fazer algum comentário em relação ao painel? Enquanto aguardamos que as pessoas se conectem. Senhores comissários. A senhora vice-presidente quer tomar a palavra? Tem a palavra, por favor.
Thank you very much, Honorable Vice Chair of the working group. Mine is just to commend you and the president of the chair of the working group for organizing this panel, and to thank all the panelists for their very insightful contribution to this debate, which I've all noted, and just to congratulate you. That's all I want to contribute. Thank you very much.
Obrigada, senhora vice-presidente. Alguma novidade em relação às pessoas inscritas, senhor Ituel? Alguém regressou para a linha? Conseguiu conectar-se? Senhor presidente Idrissa, parece-me que temos problemas de conexão e todas as inscrições que nós tínhamos não foi possível trazer qualquer contribuição. Devolvo-lhe a palavra para os posteriores procedimentos. Obrigada.
Merci beaucoup, Madame la Présidente. Voilà, nous notons avec regret peut-être qu'il y a eu quelques problèmes de connexion pour ceux qui s'étaient déjà inscrits, mais qu'à cela ne tienne, on va s'en tenir au développement interactif qui a été fait par les communicateurs que nous avons eus ce matin. Alors, je propose qu'on leur retourne la parole pour leur propos conclusif, chacun 2 minutes, si je souhaite, avant de clôturer ce panel. Donc, nous allons peut-être commencer par M. Michel Kalemba et lui donner peut-être l'opportunité de compléter, s'il le souhaite, quelques éléments de sa communication, mais très rapidement, en 2-3 minutes. M. Kalemba, vous conclusez.
Pour mieux sécuriser l'abolition de la peine de mort, il faut ratifier tous les États qui n'ont pas encore ratifié le deuxième protocole facultatif se rapportant au pacte international relatif aux droits civils et politiques. C'est ce pacte qui est le seul traité international qui interdit les exécutions et qui a pour but l'abolition totale de la peine de mort. Alors, ce texte requiert des États qui l'ont ratifié de renoncer définitivement à la peine de mort et permet de garantir de façon pérenne le non-rétablissement de la peine de mort. Et au-delà de cela, il y a aussi un projet du protocole additionnel à la charte africaine qui n'est pas encore adopté par les États membres de l'Union africaine. C'est le moment d'ailleurs pour le dire, pour la société civile de pouvoir mener un plaidoyer allant dans le sens pour que les États membres de l'Union africaine puissent l'adopter. Alors, pour conclure, je dirais ceci. La reprise des exécutions capitales en République démocratique du Congo est une expression d'une politique criminelle qui est déjà essoufflée et obsolète. Je vous remercie.
C'est moi qui vous remercie. Docteur Ndolovo, je vous donne la parole pour vos propos conclusifs. En 2 minutes. Ouais.
Thank you so much, Honorable Commissioner So, and to my fellow panelists and to all that are listening. We applaud all the countries that have completely abolished the death penalty. Can you hear me, Commissioner So? Can I proceed, please?
Oui, oui, d'accord.
Thank you so much. We applaud countries that have completely abolished the death penalty in line with the obligations of the Charter, and continue to encourage those that have not, perhaps to move towards the abolition, and perhaps not to lift any moratorium. As the previous speaker has said, that the situation in DRC is retrogressive, and perhaps we have to engage at the highest levels, the DRC authorities, to continuously support them, perhaps in transforming the laws in line with the obligations of the Charter. And more importantly, as I conclude, and to emphasize on my presentation, that the move towards the abolition of the death penalty must be informed by the structural issues that lead to criminality, that lead to all the challenges that we have in society. At the end of the day, we want to create an Africa fit for its people, and the people fit for its continent, dealing with unemployment, with poverty, with hunger, to an extent that all of us feel secure, feel safe in our spaces, without any need of talking about the death penalty. And lastly, Chair, just to say that in addition to my submissions, if we're going to create common standards in relation to the African Free Trade Continental Agreement, it should be common standards in terms of rule of law as well, in terms of the abolition of the death penalty. Thank you so much, Chair.
Merci beaucoup, docteur, pour cette conclusion. Je voudrais à présent donner la parole à Madame Ana Celeste Januario pour ses propos conclusifs.
Muito obrigada, honorável comissário-chefe desse painel. Tenho 5 notas finais. A primeira nota, que é também importante para esta área, que é ligado à proibição de extradição de estrangeiros para países que se aplica a pena de morte. Penso que isso também é importante aqui falar e, por exemplo, em Angola temos essa norma. A segunda nota, reforçando aquilo que já disse no início, somos a favor da manutenção da moratória e temos votado nesse sentido. A terceira nota, que também somos a favor da adoção de um documento africano específico para a abolição da pena de morte. A terceira nota. A quarta nota, recomendar que os países que ainda não ratificaram o protocolo adicional das Nações Unidas que o façam. E a quinta e última nota, que sempre que falarmos da pena de morte, devemos olhar para o Death Penalty in Law e o Death Penalty in Practice, ou seja, a pena de morte na lei e a pena de morte na prática. Muito obrigada.
C'est moi qui vous remercie, Madame John Mario, pour votre participation. Je ne sais pas si Madame, si c'est le cas, je vous donne la parole pour ces propos. Je ne la vois pas aller. Je voudrais, Monsieur le Président de la Commission, sur cette note, dire quelques mots avant de conclure ce panel et vous rendre la parole. Je voudrais me faire du débat qu'on a eu sur cette question de l'abolition de la peine de mort par rapport aux enjeux sécuritaires en Afrique. Pour l'essentiel, je dirais que ce panel a largement atteint son objectif, malgré le fait qu'on n'ait pas eu la chance d'avoir cette séance de questions-réponses avec le public qui assiste normalement à notre session. Je retiens au moins deux éléments. Le premier élément, c'est qu'il est ressorti des débats qu'il n'y a pas une relation établie entre l'abolition de la peine de mort et l'aggravation des défis sécuritaires dans notre pays. Et la conclusion que j'en tire, c'est que ces défis sécuritaires ne peuvent pas et ne doivent pas constituer un obstacle à l'abolition de la peine de mort. Ça, c'est une première conclusion que je voudrais tirer. La deuxième conclusion que je tire, président de ce débat, c'est que l'évolution de la situation de la peine de mort en Afrique a montré que les moratoires que nous observons sont dans un équilibre très précaire et qu'il nous faut développer des stratégies pour les consolider et les renforcer. Pour cela, je profite de cette tribune pour lancer un appel aux organisations, aux INDH, mais également aux États membres, vraiment pour qu'ils développent des stratégies tendant à consolider les moratoires dans les différents pays qui n'ont pas encore pris l'option d'aller vers l'abolition. Voilà, donc sur ce, je voudrais réitérer mes félicitations et mes remerciements à tous les panélistes et vous rendre la parole, Monsieur le Président, pour clôturer définitivement. Merci beaucoup à Madame la Vice-Présidente également de notre groupe.
Merci beaucoup, commissaire Idrissa. Trois panélistes également méritent les remerciements de la Commission et Madame la Vice-Présidente de ce groupe de travail. Nous avons eu droit à un panel de très haut niveau. Je pense que nous devons tous apprécier. Si nous étions dans la même salle, vous auriez mérité les applaudissements. Quand les interventions étaient de qualité, et nous vous en sommes en tout cas reconnaissants. Nous espérons que nous aurons encore droit à ce type de débat la fois prochaine de très haut niveau. Je voudrais quand même exprimer un clin d'œil au nom des autres commissaires, à la commissaire Sylvie Kaitesi, l'ancienne présidente du groupe de travail sur la peine de mort, qui nous a fait l'honneur de venir ici prendre part à ce débat. Ça fait un plaisir de réécouter sa voix. Et la note qu'elle a présentée, c'était une note exhaustive au sein de laquelle, en tout cas, nous avons puisé beaucoup d'informations pertinentes sur la situation de la peine de mort. Merci en tout cas à vous tous pour la mise à jour de nos connaissances respectives sur la situation de la peine de mort dans notre continent. Ceci dit, conformément à l'agenda, je pense qu'on met un terme à la journée d'aujourd'hui, tout en félicitant aussi le secrétariat qui nous a fait un agenda de très bonne qualité. Il ne nous reste qu'à souhaiter bon après-midi. Merci à nos collègues qui sont dans les cabines. Merci à la vice-présidente, Madame la secrétaire. Merci aux commissaires et aux collègues du secrétariat. Nous allons encore nous revoir demain à 9 h. Nous demandons à nos collègues du secrétariat d'être là à temps pour que nous commencions à 9 h. Bon après-midi et à demain.